I'll make a note. Good evening, everyone. I'm calling to order the continued public hearing for conditional use application 25-04 filed by MCD7 LLC. Please stand for the Pledge of Allegiance. I pledge allegiance
and to the republic one nation, indivisible, with liberty and justice for all.
Okay, well, those two are working it out. This meeting is being recorded and live streamed through the Limerick Township YouTube page at youtube.com/Limerick Township 1726. I want to thank everyone for joining us tonight, both here in our rooms and from home. We recognize the considerable time and preparation that the members of the community, the party status members, the applicant, and the township staff have committed to this process. As a reminder, this is a formal quasi-judicial hearing governed by the Pennsylvania Municipal Planning Code. The board's responsibility is to conduct a fair, orderly, and lawful hearing, to hear the testimony, to allow appropriate cross-examination, to ask questions, and to build a complete and accurate record upon which a decision will ultimately be made. I also recognize there are continued to be strong feelings surrounding this application. I ask everyone to remember that we are all neighbors and members of the same community. When we concluded the July 21st hearing, the remaining cross-examination of the applicant's first two witnesses, AJ McNaughton III and Anthony Maris, had been completed. The board also completed its questions of both witnesses. The applicant did not conduct redirect examination and either witness at the time, but reserved the right to recall them if necessary. I also reserve the board's ability to recall Mr. Maris should appropriate questions arise. The applicant had no additional witnesses available that evening. Therefore, tonight, we expect the applicant to continue presenting its case with additional witnesses. Our solicitor, Rebecca Geiser, will establish the precise order of the witnesses and testimony for the record. As we continue to ask everyone to treat this room as you would any courtroom, our stenographer must be able to hear and accurately transcribe everything that is said. That transcript becomes the official record of this proceeding, and it will be very important during the board's consideration of the application and any subsequent appeals. Please silence your phones and other electronic devices. Interruptions, outbursts, crosstalk, and side conversations cannot be permitted. If the stenographer cannot hear, the proceedings will have to be started until order is restored. The Pennsylvania Municipal Planning Code establishes time length and procedural requirements for these hearings. We must continue to make meaningful and effective progress while protecting everyone's procedural rights. Dr. Walraven was unable to attend our July 21st hearing while recovering from a medical procedure. Dr. Walraven, have you reviewed the complete transcript from the 21st hearing, and are you prepared to participate in tonight's continued hearing?
I am.
Okay, and with that, I will turn the continued hearing over to our Township Solicitor, Rebecca Geiser.
Thank you. Just as a housekeeping matter, I did receive communications from Evergreen Development Group LLC's attorney, and that was shared with all the party status individuals as well. They just wanted the record to reflect that they will not be here tonight. However, they still wish to maintain party status, so I'm just sharing that as part of the record. I don't know if any of the attorneys or party status people or have a statement regarding that.
No.
Okay, thank you. With that, Mr. Campbell left off. I believe he has a new witness, and we're going to proceed in the same order that we did the last time. So Mr. Campbell will ask questions. Eventually, there will be cross-examination. Floor is yours, Mr. Campbell.
Thank you, Ms. Geiser. One comment to begin with. I appreciate your summary, Chairperson Lawson. You indicated that we had no more witnesses at our last meeting. In fact, we did.
Yes.
It was obvious we weren't going to get to that witness, so we moved on. And I make the point because I appreciate the effort that the board is making to hear it, and we want to take advantage of that time. So Ms. Carr returned tonight to testify. She is our landscape architect, and I ask that she be sworn in.
My name is Danielle Carr. I'm employed by Labella Associates DPC. I do.
Ms. Carr, can you tell us what you do for a living?
I'm a landscape architect.
What do you need to do to become a landscape architect?
So there's an educational requirement and let's see, work experience under a licensed professional, and then there's a licensing exam.
And where did you get your educational experience to qualify you as a landscape architect?
Attended accredited university, SUNY, State University of New York College of Environmental Science and Forestry.
And at the risk of being impolite, how long ago was that?
1988.
Okay, so how long have you been a landscape architect?
So I became licensed in 1990. I've been practicing as.
Can you speak up a little? I think
Sure.
we're having difficulty hearing. Yes.
Sure. Obtained licensure in 1990. So I have over 35 years of experience as a licensed landscape architect.
You are licensed in New York, correct?
I am. I also have an inactive license in Pennsylvania. That's actually where I became licensed.
As a landscape architect, do you work on project in multiple states?
I do.
For Labella, what other states and jurisdictions do you prepare landscape plans for and serve as a landscape architect?
Probably 12 to 15 other states. Closest to Pennsylvania would be Ohio, New York, Maryland, Delaware, Virginia.
And your responsibilities as a landscape architect, do they involve other projects of an industrial use similar to data centers?
Yes, about 60% of my work, or the majority of my work, is very specific to preparing mitigation plans for large-scale developments similar to this data center proposed project, things like a regional warehouse facilities, power infrastructure projects, wastewater treatment plants, power generation plants.
About how many landscape plans have you prepared for large-scale industrial uses? If you can estimate how many.
In the last year, at least 30, 35.
Is that for how long past in your career has it been about that level of preparing plans for large scale industrial uses?
These type of plans, like I prepare plans, on a weekly basis for municipal reviews for environmental permitting and similar permitting requirements. So I'm the specialist for the firm, so it's been probably at least the last 15 years for power infrastructure projects.
And have you prepared landscape plans for other projects in Pennsylvania?
I have.
Is it common for a landscape architect to come and testify?
It's pretty uncommon, actually, pretty unusual.
Have you testified before a municipal body of some sort? Have you offered testimony in any other jurisdiction?
I have.
How many times?
To potentially 3 times.
Yeah. So how many landscaping plans have you put together, let's say, in the last 10 years?
10 times, at least 50 a year.
And you've only been required to come to a facility and testify a handful of those times, correct?
That's right.
All right, I'm going to show you a document that I'll mark as A13. Is that your resume?
It is.
Does it accurately summarize your professional qualifications?
It does.
I previously circulated this in anticipation of the last meeting, so I don't know who else needs one. I have a handful of other copies.
Does anyone need a copy? You can raise your hand if you need a copy and he will get it.
So at this point, I would offer Ms. Carr as an expert in the area of landscape architecture.
Thank you. So again, as you heard, Mr. Campbell is asking to qualify this witness as an expert. So you'll be given the opportunity to ask some questions of Ms. Carr, but they should be limited to her qualifications, her experience, her education, her background, obviously not the substance of her testimony because she hasn't testified yet to that. So are there any questions in the township, Your Fury?
Yes, Solicitor Geiser, I have a few questions on voir dire, please.
Please go ahead.
Thank you very much. Ms. Carr, when were you licensed, registered landscape architect in Pennsylvania, and how long has your license been inactive?
So I was licensed in October of 1990, and the period of registration is 2 years, so it became inactive in 1992, and that's when I applied for reciprocity in New York State. The landscape architecture license is reciprocal between Pennsylvania and New York, and actually all of the U.S. and all 50 states.
Are you authorized to sign and seal landscaping plans in Pennsylvania?
No, it's our office, the firm's protocol to allow only principals of the firm to sign and seal plans. So I'm not a principal of the firm, so only a principal licensed in Pennsylvania would sign and seal the plan.
So if eventually there is a landscape plan that's required to be filed with the township under land development ordinance, someone from your firm will be signing and sealing that, but that would not be you.
That's correct.
And you're have in the 2 or 3, the 3 times I think you said you testified. Were you qualified as an expert to testify with regard to a woodland study?
With regards to a what study? I'm sorry.
A woodland study. Yes.
Actually, one of the 3 times.
And can you explain where and when that was, and what were the other 2 testimonies about?
So I'll say it would be the city of Ithaca, New York, for a similar large-scale development. I am, at the time, I was not working with Labella Associates, the firm that I worked for. I worked with environmental scientists, a horticulturalist, and an arborist to prepare a woodland restoration plan. So the city of Ithaca has pretty robust code requirements, municipal code requirements, and also they're very strict on environmental impacts, notwithstanding the New York State environmental conservation and the seeker process there.
And approximately when was that, please?
I would say, I believe it was 2008.
And you said you testify as an expert in 2 other matters not related to woodland studies?
That's right. The other 2 were for visual impact assessments or visual impact evaluations.
And when was the last time you testified as an expert or qualified to testify as an expert?
2016.
And at that time, you were not licensed in Pennsylvania, but you were licensed in New York.
That's correct.
Thank you. Those are the questions I have.
Mr. Chesney?
Yes.
Good evening, Ms. Carr. My name is Lawrence Chesney. I'm an attorney here this evening on behalf of the Springford Area School District. Just a couple of questions, if I could.
Go ahead.
With respect to the inactive status of your certification, if you go on to inactive status, what exactly does that mean?
It means I have a license in Pennsylvania, but it's currently active. So the state doesn't have my current address. They would need to confirm that I have upheld the continuing education requirements of Pennsylvania. They're similar, very similar to New York State.
Okay.
And it also means that I cannot, it's a title and practice law. I can't sign off on work in Pennsylvania.
Okay. In Pennsylvania, if as an attorney, if I go on to inactive status, I can't hold myself out as an attorney or practice law. So is landscape architecture different from that?
It's not different, but I prepared this plan representing, well, as a team member of Labella Associates. So
I understand.
it's not me that's preparing these plans, it's the firm. And so the principal, Ryan Kelly, who does have a Pennsylvania license, he would be signing the plan, and he does have a Pennsylvania license that is active.
Okay, will he be testifying as an expert in this case?
He won't.
Okay, so you're being presented as the expert, but you don't have an active certification, correct?
Let me interrupt. If required, we will produce additional witnesses on that issue. This witness is the witness who physically prepared the plan. I think she's valuable to share her insight about the landscape plan and the woodlands plan.
I don't disagree with that. I think that's correct, but you're presenting her as the expert.
An expert doesn't mean we can't submit additional.
Okay,
if required.
understood. And you indicated that you had testified as an expert on approximately three occasions. Is that correct?
That's correct.
And if my notes are correct, that none of them were in Pennsylvania. Is that right?
That's right. They were all in New York State.
Right. And in New York State, you do have an active landscape architecture certificate. Is that right?
I have a current landscape architecture license.
License. Okay. And in taking a look at your CV, none of the projects that you have been involved in reference a data center. Is that correct?
That's correct.
So this is the first one you've been involved in?
Yes,
I saw a lot of other energy or solar projects. Is that right?
that's correct.
But this is the first data center.
Right.
And the Labella firm is the same firm that Mr. Magnotta, who had testified earlier, it's the same firm he's with, correct?
That's right. I'm part of the professional consulting services team.
Okay. And did you prepare the landscape plan for this project?
I did.
Okay, but you can't sign it since your status is inactive. Is that correct?
That's right, but it's firm protocol for me to not sign it whether or not my Pennsylvania license is active.
Okay. So the reason you're not signing is because of your firm policy, not necessarily what the law says.
That's right.
Would the law prohibit you from signing the plan if your status is inactive?
Yes.
Okay. That's all the questions that I have. Thank you.
Thank you. Mr. Fogarty?
I have a question. Thank you.
Okay. Mr. Bailson? Mr. Bailson's not here, that's right. Ms. Otero?
Good evening, Ms. Carr. So just to follow up, you talked about your inactive Pennsylvania license. You said that it went inactive in 1992.
That's right.
Okay, so I'm looking at a Pennsylvania Department of State certificate that has your information on your license. Does it seem accurate that your license actually expired May 31st, 1991?
That could be accurate. I have not gone on the website and reviewed it carefully.
And just looking at your resume, you do have quite a few projects, but none of them are in Pennsylvania. Is that correct?
That's right. None listed on the resume. The projects listed on the resume are similar in scope and scale and development intensity to this project.
But not in Pennsylvania.
No.
Correct? All right, that's all I have. Thank you.
Thank you, Ms. Otero. Are there any pro se party status individuals that have questions for Ms. Carr? Again, this is just voir dire. This is related to her credentials, her background, not the substance of her testimony. I am seeing none. Do I have, oh, okay. I wanted to check if there was anybody first. We can go out of order. And again, these questions should only be limited to the background and credentials. Okay? Ms. Saxick, go ahead.
Okay, good evening. Ms. Carr, when were you asked to provide a CV for this hearing?
Approximately, I don't know, about a month before the last public hearing.
And what did you submit?
I submitted a detailed resume with examples of similar projects.
So that's the 3-page document in front of you?
That's right.
Okay. I want to put a note that what we were given as evidence was a single page. It was 1 paragraph and a summary. We were not given the 3-page CV.
So for the record, and I'm sorry, I forget the opponent's name. It is true that, and I'll mark it as A14, we circulated a 1-paragraph summary in advance of last month's hearing, and then we supplemented at the last hearing the actual resume, which is reflected as A13. So I believe both A14 and A13 have been in the record for over a month. I physically handed out A13 to anyone who asked for one at the last meeting.
I want to clarify that not all of the party status individuals got the 3-page CV. And so the one paragraph summary is A13 then?
No, A13 is the resume which was previously handed out and previously submitted. A14 was submitted probably a week before that time. A14 is the one paragraph summary that you're referring to.
In future, is it possible to get the documents online in the digital file?
You have to ask the applicant. We provide the township.
Yeah,
Yeah.
I've submitted the documents
Right.
to the township, and they go up on the board.
I can be clear, there is no legal requirement for this witness to provide anything prior to tonight's hearing. Everything that's been provided has been voluntarily done. So there's nothing in the MPC requiring there. This is not discovery. There's not like a civil litigation case.
Just bad faith, but thank you for your answers. That's all concerning the credentials.
Thank you, Ms. Sassett. Mr. Byrd? No question? Yes. Oh, thank you. Anybody else have questions? Just again, on her background and credentials, we're not talking about the Woodland study yet. Well, go. And again, these are cross-examination questions, not procedure questions, not.
I just thought we agreed that we would get information 10 days prior, and that has not happened yet.
Okay.
Every time we're getting things last minute, piecemeal,
I understand.
handed to us, and
that is an issue for the applicant.
well, it should be noted in the record that we've been promised and they are not delivering at all. Not yet.
Yes, that's been noted.
We
in
even
the
got
record.
emails 5 minutes before we came here.
Okay, that's been noted in the record. Are there any other questions regarding? Ma'am, what was your name? Thank you, Paul.
So if I could respond, I agree that there was an email that came late this afternoon. It wasn't from me. It was from one of the other attorneys who offered documents. And I shared Ms. Geiser's comments that there's no obligation for Mr. Fogarty to share them in advance. He did. And I reiterate what I said in response to the last series of questions. Ms. Carr was here last month in July. We circulated her resume at that time. So her full 3-page resume has been in the record and circulated among the parties for over a month. About a week or so in advance of the hearing in July, the one paragraph A14 was circulated. We're doing our best to put things through the electronic medium, through the township, well in advance of the meeting to facilitate an efficient meeting, and we'll continue to do so.
Okay. Are there any board questions regarding Wadier, the background and qualifications of Ms. Carr?
Ms. Schulman? No. Dr. Walraven?
No questions.
Mr. Maroney?
Don't have any questions.
Bonnie Lawson? I don't have questions.
Is there a motion to accept Danielle Carr as an expert witness in landscape architecture?
That's my motion. Just kidding.
Motion to accept?
Thank you.
Oh, do you want me to finish? We have a motion in a second. Yeah. All those in favor?
Aye.
Aye.
Nay.
Okay. Motion fails.
Motion fails on a tie vote.
Oh.
Maybe we should. I'm stunned. Let me make a little bit of argument. The standard,
Okay.
the standard for accepting an expert is that they have more knowledge than the general layperson. I think the record has clearly demonstrated that this witness qualifies under that standard. There may be other issues, but respectfully, I think it's inappropriate for the board not to accept this witness as an expert in landscape architecture. I'd ask the board to reconsider. If you want to take a moment to consult, I'm happy.
You can certainly take an exception.
I'm going to request an executive session so that we can get guidance from legal.
Thank you.
Okay, we're back on the record. And after discussing with the board and legal review, they are willing to accept her as a fact witness, however, not as an expert. They don't feel she's met the qualifications necessary for an expert.
Okay. Note my objection.
Yes, objection noted.
So Ms. Carr, what role did you play in preparing the woodlands mitigation plan and the buffering plan?
So I developed the buffer area and screening plan based on the woodland survey and also based on the code requirements for the property line buffer.
Mr. Kirk, can I ask you to put up on the screen the screening plan? And For the record, I'm going to mark the Woodlands report as A15. And I'm going to ask that the screening plan, which is page 11 of 14 on the set that was previously submitted as A16. And then there's an additional plan that's also part of the plan set, which we'll refer to as A17. A16 is up on the screen. Yes, you do. That was circulated in advance of last month's meeting.
All right, so that's different than the one with the original plan.
I recirculated, we recirculated it in anticipation of Danielle being testifying last month. I don't know, we submitted it. Okay.
It's different from the one thing.
What? Yes, because that's a completely different sheet. That's not the screening plan. Screening plan is page 11 of the set.
Oh, what it is? Page 21 in this appendix? No. I'll just follow that.
Okay, thank you.
Can you please keep it down on this side of the room? Our stenographer needs to be able to hear everything, as does the board. So outside talking really makes it difficult.
Just a question, Mr. Campbell. I have. Yeah, thank you. I have the buffer area and screening plan sheet 11 of 12. Was that was a different submission from the 11 of 14, or is it just the same plan?
I believe it is absolutely the same plan. I don't know why that's differently numbered. No idea.
This might have been like from the first or second hearing.
It may, or part of the original set, but the screening plan has not changed.
Okay, thank you.
So just for a point of clarity, it doesn't matter if it was what the initial documents we were given or the new documents, it's the same.
It's the same plan. There's been no change to the screening plan. The numbering on the submissions may differ, but it is the same plan.
I just wanted that cleared for the record.
So I want you to take a look at what's on the screen.
So point of clarification, previously the buffer area and screening plan was A8. Are we changing the numbers?
Thank you. This is A8. Let's call it A8.
Okay, A8 is the buffer area and screening plan. Number 11 of 14.
Correct. Thank you. Correct.
Perfect. Alan, do you mind returning the mic to, thank you. I'm sorry, but thank you. Appreciate it.
Yeah, my recollection is that Mr. Magnotta used this as an exhibit previously. Did you prepare A8, which is on the screen as page 11 of 14?
I did.
Okay. And what's the purpose of preparing that?
So the purpose is to show compliance or demonstrate compliance with the woodland replacement requirements and the property line buffer requirements.
So in order to do that, did Labella prepare a woodland survey?
Yes, Labella prepared a woodland survey.
And is that part of the team that you work with at Labella?
That's part of the team. I did not participate in preparing that survey.
But are you familiar with how it was prepared?
I am.
And how is a woodland survey prepared? How did Labella prepare this?
So it's a pretty standard method of surveying woodlands. It was prepared in coordination with the town engineer. The town engineer approved and directed the methodology. And the trees were sampled and characteristics and quantity.
Were they documented?
Calculated,
Were they
yeah,
documented at 815?
Yeah, yes.
Okay. And how is the area determined to be surveyed? What are you looking to capture in the survey?
So the code requires replacement of 50% of the woodlands cleared. Proposed cleared woodlands is 38 acres. So a survey of 19 acres to be replaced was required by the woodland survey.
So to be clear, my understanding is that the ordinance allows the first 50% of woodlands to be removed without replacement, correct?
That's right.
And it's the second 50% that then needs to be replaced, correct?
That's right.
And when we say replaced, what are we talking about in terms of caliper or the replacement module or measurement protocol?
So it's 1-for-1, and in this case, woodlands are quantified by caliper inch of trees. So it's 1 inch of tree caliper provided or replaced or restored for each 1 inch caliper removed.
And in 815, was there a catalog, if you will, or a survey of the trees to be removed?
There's a tabulation in, I believe it's appendix 6C or C that quantifies the overall number of trees and caliper inches of trees.
And based on that, what do you use that for in terms of preparing what's shown on the screen is A8?
So we used that overall quantity of trees. So it was in the order of just over 25,000 caliper inches. We need to provide that quantity in the woodland restoration.
In terms of woodland restoration, where are you allowed to plant the trees to qualify for the woodland restoration requirement?
So the plantings shown on the buffer area and screening plan show plantings around the perimeter of the site along the property line primarily, because we're restoring woodlands and also meeting the property line buffer requirement.
Does the ordinance allow you to use the required perimeter buffer for the purpose of replacement planting?
It does. And that's confirmed in the December 2025 Pannoni engineer's letter.
Using this laser pointer,
Sure.
can you identify the areas in which you propose through the buffer plan to replant the required trees? Or I should say plantings. Yeah, press that.
So I'm gonna start.
Yeah,
Speak into the microphone, please.
I'm gonna start at, is it Evergreen Road? You can see this narrow green line around the property. Here in this white area, that's existing woodlands. Those will remain. And here, this greater or wider green area will be, it will be more intensely, a greater area will be planted, not just along the property line. No planting in the wetland or water course. Again, like more property line buffer and woodland restoration planting around the perimeter of the property, around the proposed substation and switching station. This area, it's narrow, at least like the 25-foot with minimum buffer here, there are steep slopes here around the property, and back to Evergreen Road.
In order, what's the total number of caliper inches that need to be replaced?
So it's 25,000, and I believe it's 25,038, I'll say, and we are providing, with the proposed planting, 25,500.
In terms of the replacement plantings that you're proposing, how many actual plantings are there approximately?
So we have a variety of different plants. If I follow a 4-inch caliper tree size replacement only, that's 6,300 trees of 4-inch caliper size, but we're proposing a variety of plant sizes and types to follow the design criteria of the code.
Talk a little bit about the design criteria required in the code and the type or the diversity of plantings that are then resulting in the buffer plant.
Sure. The code, we've provided a high intensity type buffer planting that requires a variety of different, I'll call them types of plants: deciduous trees, evergreen trees, shrubs, large and small shrubs. And there's a mix and quantity and a minimum size. Those are all spelled out for each of those plant types in the code. So we followed the high intensity buffer type module. The minimum property line buffer module size is 25 feet wide or deep by 100 foot long. And on the plan, that buffer will be wider, where you can see visually that it's not just along the property line, but in the interior of the site. So according to the high intensity buffer type, total planting area to achieve that 25,500 caliper inches is 978 large deciduous trees, 652 small deciduous trees or ornamental trees, 4,075 large evergreen trees, 2,900 large shrubs, and 5,500 small to medium shrubs.
Ms. Carr, you're reading from a chart, correct?
I am.
And is that chart on the bottom left-hand corner of A8?
That is.
And on the top left-hand corner of A8, there's other notes, correct?
There are.
And we've taken those notes and put them on a separate sheet, correct?
That's right.
So, Mr. Kerr, can you put up the screening detail sheet?
So the table in the lower left-hand corner includes
just
the
for
quantities I just listed.
I don't recall if Mr. Magnotta referenced this before. So I'm referring to it as A15 if we can. Unless someone wants to correct it. These are notes. This is a separate exhibit. These notes are exactly on A8. So they're easier to see.
Okay. So it's in the top 10.
Microphone.
Yes.
Sorry. So that is the top left-hand corner of the diagram.
Correct. And the bottom left-hand corner.
Okay.
Thank you. I had as exhibit 15 was the woodland mitigation plan. So this would be 16 then?
Yes. Sorry.
Okay.
So point of clarification, so the A8 was the buffer plans and screening, buffer area and screening plan. A9 that was previously given was the buffer area screening details.
That's what.
Yes.
Thank you for the correction. What's on
So-
the screen is A9.
Yes, and then the woodland survey. Right, it wasn't marked, I think, separately, but also I only have so many hands, so.
So the buffer area and screening plan is A9, it's up on the screen. Is the detail on A9 enlarged copies of the details that are on A8?
Yes,
Okay, so it appears to show a 100-foot by 25-foot cross section of sorts, correct?
that's right.
So what is that?
That is a typical buffer planting module. So that would be repeated along the property line.
In other words, for every area that's generally that dimension, 100 by 25, these are the plantings that would be placed in that
Area.
And what type of trees are going to be planted in every 250-foot square foot area, 100 by 25? Sorry, 2,500 foot area.
So we've not identified species. We've identified the types in that table that follow the design criteria of the code.
So I was going to say, where are those design criteria found?
It's in 155, 27, it's 3 or 1, 27.1.
And have you designed that table to reflect the types of trees consistent with the SALDO provision relating to tree plantings?
Yes.
And does the SALDO provide discretion in terms of the specific species that satisfy those requirements?
Yes.
So I'm preparing the screening plan and the screening detail. Did you review, what sections of the township's ordinance did you review when you were preparing?
Well, we reviewed, is it 184-87 that talks generally about the woodlands replacement? But 155, 27.1 talks about buffers and screens. Included in 155 is there's a list of recommended plant materials. Although that will be more useful for a detailed planting plan. We also looked at 155-27.3 that defines each of the plant types and the minimum size that they may be installed. It also talks about required maintenance by the applicant, property owner, and the landscape bond or guarantee required for all plantings.
Are you confident that the woodland survey, using the protocols that were used, accurately identify the total caliber of trees that are going to be removed and need to be replaced?
It does. It actually uses a more accurate methodology because it doesn't, they quantified and qualified the trees for each of the acres, 19 acres that would need to be restored rather than averaging the tree sizes and quantities through all of the area.
You referenced a Pannoni letter, I believe reissued December 30th, 2025. Did Pannoni comment on the woodland survey and the tree replacement plan as represented in the screening plan and the screening details?
Yes.
And what comment did they make?
So they confirmed that the provisions of 184-81D do not apply, and up to 100% of the woodlands is permitted to be cleared or developed if the following conditions are met. The first 50% of the woodlands can be cleared or developed, and 50% cleared with no replacement, and the remaining 50% replaced.
And did they comment on whether or not what you propose complies with the ordinance?
So it does in that comment 8, part 3, or just below 2, it says yes.
Go ahead, read.
Based on the tree assessment provided, the total caliper inches DBH of disturbed woodlands in excess.
Gotta slow down, sorry. So she can record you.
Based on the tree assessment provided, the total caliper inches DBH of disturbed wetlands in excess of 50% of total woodland disturbance, 19 acres, is estimated to be 25,023 inches, and a total of 6,256 trees with 4-inch caliper will be replanted to comply with this code section.
And following comment 3.
Following comment 3, it also says, based on the tree assessment provided, the applicant will comply with this code requirement.
Mr. Kirk, can you go back to A8, the screening plan? Ms. Carr, on the screen is A8, which is the screening plan. You've identified the area in green around the perimeter, primarily around the perimeter as the area for buffering, correct?
That's right. That represents the woodland restoration area and also meets the property line buffer requirements.
Are there areas located on the site that provide land for additional plantings if necessary?
Yes, so what's not indicated or counted as part of the buffer and area and woodland restoration are plantings required for the stormwater management basins, and also around to screen parking areas and interior developed areas.
And would plantings in the stormwater basins, if necessary, count towards the tree replacement requirement?
They do per the code.
But you're not counting any of those, correct?
We are.
So we are or we are not?
We are not.
And plantings in and around buildings and in the parking lot would also count for the tree replacement requirement, correct?
That's correct.
And you're not counting any of the plantings along and around the perimeter of the buildings or in the parking lot as part of the tree replacement plan, correct?
We are not.
In addition, are there any other pockets where you could make the landscape buffer deeper or thicker or larger to add additional plantings if required?
Yes, we would propose that those be where there are adjacent residential uses.
You can make those buffers a little bit bigger if necessary.
That's right.
What do you intend to accomplish with the buffering plan?
To mitigate the visual impacts of the development and to restore removed woodlands.
And you believe the buffering plan as designed will in fact mitigate the visual impact of the development?
Yes, it complies with the requirements of the code.
And the purpose of the code is to achieve that end, correct?
That's right.
Can you generally describe the type of plantings that are proposed in terms of their height and diversity within the buffering and screening areas?
So it's a mixture of trees and shrubs. Some are deciduous, meaning they'll leave lose their leaves in the fall and the winter, and some are evergreen, meaning they'll retain their foliage year round. The intent is to mimic or restore a naturalized vegetation, and that will eventually mature into a woodland.
Is there a value or a purpose in using a diversity of plantings?
There are, for both aesthetic reasons and just for cultural reasons, aiding in plant establishment and survival.
When you say cultural reasons, you're talking in the field of landscape
Growing.
architecture.
Yeah, growing.
And what are you trying to protect against by having a diversity of plantings?
Well, we want to encourage species diversity with plants so that it can support species diversity in insects and other fauna. And we also want to protect against any potential damage by pests or diseases.
What are the factors that you can anticipate might impact the viability of any particular tree or any particular planting?
Soil conditions, weather conditions, things beyond the control of the installer and the maintainer.
And if the plantings fail because of disease or because of weather-related issues, whose obligation will it be to replace and maintain those plantings?
So it's the applicant or the property owner. Code requires the applicant to provide a bond or warranty for 18 months following accepted installation. And then for the plantings, the landscape to be maintained for the life of the use of the property.
How does the landscape plan address screening of things like the utility switchyard and the substations and the storage yards? Is there a different standard for that?
There are more stringent screening requirements for those types of uses, in particular parking, the pump station, the substation.
And is the screening and buffering plan designed to meet those different standards for those particular facilities or components?
It does not. Those would need to be added in addition to this.
That would be part of the landscaping, the land development plan?
That's right.
Is the applicant prepared to revise the landscape plan to address comments from the township board's consultants as part of this process and as a part of a future land development process?
Yes.
We talked about the survival of those trees. Well, realistically, what's the expected survival rate or anticipated survival rate of the plantings in the buffer area for, let's say, the first 2 years or 3 years of installation?
Typically a new planting, a restoration type natural planting or an ornamental planting, we expect a 10 to 15% mortality rate, and that usually occurs within the first year and a half, 2 years.
And then those trees would have to be replaced.
That's right.
Those are the questions that I have for Ms. Carr.
Thank you. Cross-exam from Township Solicitor Mike Fury.
Thank you very much. Am I correct that detailed plannings associated with any stormwater area would have to be designed? At this point, it would be speculative. Is that correct?
That's right.
So can you restate the question?
Sure. I was just asking if detailed plannings associated with any stormwater areas would have to be designed, because it's speculative at this point. The stormwater areas are not designed. Is that correct?
Well, they do require plantings, but those plantings are not designed conceptually or specifically as part of this plan.
And And so that would be subject to engineering and then
That's right.
subsequent design of plantings. Is that correct?
Yes.
And then the landscape plan will have to be signed and sealed by a registered landscape architect. Is that correct?
Yes.
Solicitor Geiser, I've reviewed the Woodlands report with the township engineer and just checked to see if any additional questions were to be asked. And we have no further questions. Thank you.
Thank you, Mr. Fury. Mr. Chesney?
Yes, thank Ms. Carr, again, Lauren Chesney on behalf of the school district this evening. A couple of questions with respect to the screening and the buffering. When you were preparing this plan, was any consideration given to the height of the buildings, of the proposed buildings?
Yes. We do consider that. I think the buffer area and screening plan itself does state in the notes that it's intended to demonstrate and comply specifically with the woodland restoration requirements and the property line buffer. So we're complying with the code, and part of that compliance is to screen views of the proposed buildings.
Correct. No, I understand what your intention is. I believe you indicated that the trees, the deciduous trees, were approximately 4-inch caliper trees. Is that correct?
So that's a method or a way of determining or quantifying the number of trees based on caliper size. The trees that will be installed will not be 4-inch caliper.
So it'd be less than that?
So because there are a variety of plants, the caliper equivalent size for, say, like a deciduous tree that would match a 4-inch caliper tree in the existing woodlands, might be replaced with a 3-inch caliper large tree and several shrubs with an equivalent total caliper size of 4 inches.
Okay, I understand. So it would be the combination would add up to a 4-inch, correct?
Right. That's right.
So for the trees that would be proposed here, what would be the height of the trees that are being proposed on your plan?
So the code requires that I'll say the minimum mature height of a canopy tree, that would be the largest. The minimum mature height is 30 feet, but what we propose for a canopy tree, or what I would call a shade tree, that tree would be 60, at maturity would be 60 to 80 feet tall.
Okay, and how long would it take to get to maturity?
Depends on the species and installed site and growing conditions. But that could be anywhere from 15 to 30 years.
Okay. 15 to 30 years to reach a height of 60 feet?
60 to 80 feet.
Okay. And
that would be for the canopy tree, which is defined in the code.
Understood. And the buildings proposed on this plan are 85 feet, is that correct?
I believe so, yes.
If you know, that's fine. And you said that there would be a mixture of deciduous and evergreen trees, is that correct?
That's right.
So
for example, an evergreen tree, we would propose trees that reach 25 to essentially 70 or 80 feet height at maturity. Those trees grow more quickly, so
right.
that would be anticipated. They would be anticipated to be mature within, again, probably like 15 to 20 years.
Okay. And the max height for the evergreens would be, would you say 60 feet?
It depends on the trees, but because of the area to be covered and the height that we want to achieve, we would choose species that get larger, probably to 80 feet.
Okay. And with the combination of deciduous trees and evergreen, there would be portions of the year where some of those trees obviously did not have leaves, correct?
That's correct. It's not unlike the existing condition.
The existing condition doesn't have an 85-foot building on it though, right?
No, it doesn't.
Yeah.
There are existing woodlands that will remain.
Understood. And I believe you indicated, if my notes are correct, that there's more stringent requirements for certain improvements to be made at the site. Is that right?
Yes, that's right.
But those have not yet been shown on your plan, correct?
Correct.
Okay. And you testified that there was a bond required by the township for the landscaping. Is that correct?
That's right.
And that's a part of the ordinance requirement?
Yes, it's in 155-27.3.
But that's only for a period of 18 months. Is that right?
That's right, but the maintenance portion of that section requires plant materials to be maintained for the life of the project, and that dead and diseased plant materials be removed and replaced promptly.
Okay, so the bond requirement goes away, but not the requirement to replace the tree, right?
That's right, to maintain it and replace plants that are not successful.
I believe you indicated in your testimony that the mortality rate for new planted trees is 10 to 15%. Is that right?
That's pretty typical of new plantings of any type.
So that would be the shrubs, the evergreen, and the deciduous trees. That rate would apply to all of those?
All of it.
And in addition to the trees, the shrubs would be planted. Is that along the border of the roadways that you indicated before? So it'd be a mix of shrubs and trees?
Right.
Okay.
Everything shown on the buffer area and screening plan.
So there would be a mixture of shrubs and trees in all of those green areas shown on sheet 11 of 14?
Yes.
Okay.
Yes.
I believe that's all the questions that I have.
Thank you, Mr. Fogarty.
Good evening, ma'am. For the record, Kevin Fogarty on behalf of MCD2. Ma'am, I think with what's up on the screen now, which is 11 of 14, am I correct?
That's right.
Where you started up on Evergreen, when you were asked to go around the perimeter, could you put your laser pointer up there and take us on the pathway from where you started?
Sure. So this is Evergreen Road. And this narrow green line represents the property line buffer.
Okay, can I stop you there for a second?
Sure.
What you just called the narrow green line, what is that going to be populated by in terms of landscaping?
That will be everything that's green shown on this buffer area and screening plan will be planted with this module of mixed plants.
Okay, well, whatever those are, when they're initially planted, what will be their height?
So the code calls out the minimum sizes, and we've listed the minimum sizes here. You can see them on that, the detail sheet.
So
A little bit larger.
when you say here, you indicated to the lower right-hand corner of A8, and you're indicating now that I think that they're shown on A9, correct?
Yes, they're shown on both. So I'll just list through or go over these. The top plant is a canopy tree. I'll call it a large tree, a shade tree. The minimum size at installation is 3-inch caliper. The height would vary depending on the species. An ornamental tree, minimum size at installation, 1.5-inch caliper, or 6 foot minimum height. So these minimum installation sizes are listed right in the code. But evergreen tree, 2.5-inch caliper or 6 foot height minimum size at installation. Shrubs, depending on large or small, 30 to 36-inch height minimum and 18 inches height minimum size.
Okay, so if I understand correctly, what you referred to earlier is that narrow green line.
Yeah.
That when they're planted, the highest piece of landscaping material or whatever it is going to be about 6 feet. Is that right?
No, that's not right.
Well,
so a canopy tree, a 3-inch caliper canopy tree or shade tree, is more likely to be 10 to 15 feet tall.
Okay, so that's going to be the highest when it's planted, correct?
That's right.
Okay, and what is the I'll call it the destination height for those trees? What along that what you call the narrow green line? What
you mean the
target?
mature anticipated mature height?
Yes, ma'am.
So the code requires, again, it lists the minimum size at installation and also lists a minimum size for a mature height or spread is. So for that canopy tree, it's 30 feet minimum.
Okay, and that's the mature height along that green line, correct?
No, not necessarily. It depends on the species that are the specific species that are planted. Mature height, as I noted earlier, may vary between the minimum of 30 feet and up to 80 feet when mature.
Okay.
But that takes some time.
Okay, I'm sorry. I thought you were done. So but that would be in 15 to 30 years?
Correct.
Okay, then if you could take your laser and go along that line there,
Mm-hmm.
thank you, which is where it's basically an L along that adjoining property, correct?
That's correct.
Are you familiar with what's proposed to be developed on that property that abuts this tract in that area?
I'm not familiar with what's proposed.
Okay, the line that you just continued there, the longer line, would, if I asked you the same questions about planting height and maturity height and things of that nature, would your answers be the same as for the other line?
They would be the same. The property line buffer is intended to meet the code requirements, which are the detail proposes, planting that complies with the code for that property line buffer at the high intensity level. And it also meets the woodland restoration planting requirements. So regardless of what's proposed for the adjacent property, that property line buffer design, planting design would not change.
Okay, and could you please put up MCD 2 Exhibit 1?
Yeah.
Just for the record, I have copies of this exhibit up here. My name was mentioned earlier as having provided just today, this exhibit and another one. Just so we're clear on the record, it was agreed at the preceding hearings that all parties would get identities of witnesses and exhibits 10 days in advance of the hearing. As of last Thursday, we had nothing. I sent an email to Attorney Campbell and said, who are your witnesses? What are your documents? What's the plan? Literally, what's the plan for next Tuesday? Got no answer. Midday Friday, there was circulation of some exhibits, I believe, for the next witness. And when I saw those, I felt compelled over the weekend to put together something to present possibly tonight, which is this exhibit I'm going to ask be put up there now. One.
So for the record, I object. This witness was identified 45 days ago with the exhibits that she's working off of submitted 60 or 90 days ago, including her resume, which would have been 45 days ago. So I don't understand what Mr. Fogarty's filibuster is about. With regard to this witness, the exhibits and the identity of the witness was identified in anticipation of July's hearing, which we didn't get to. So that's where we're picking up where we left off.
Well, that's not correct.
Oh, can we ask the questions? As I already said, there's no legal requirement. You know, I can't compel Mr. Campbell to provide ahead. As I can't compel the parties to provide ahead of time. Please ask the question.
Your boss made it.
Right, ma'am, it's not legally binding. Please proceed with your questions.
Okay, thank you. Ma'am, have you before tonight seen the plan that's up on the screen and again, which has been marked as MCD 2 Exhibit 1? Have you ever seen that before?
I have not.
Okay, so you have not seen the mixed use, which includes residential apartments for that property that was at the upper left-hand corner of Exhibit 11 of 14, correct?
I have, correct, I have not seen this plan.
Let me shift gears here for a minute. The report that was marked, I believe, as A15, the Labella report, do you have that?
Is it the woodland survey?
Well, the title on the first page is tree assessment.
That's right, tree
Correct.
assessment.
Okay, am I correct that if I go to the signature page, your name is not on this report as the preparer in any way, correct?
No, it's not. I didn't participate in the preparation of this report.
Right.
It was prepared by Labella Associates, but I did not participate in the preparation of this tree assessment.
Okay, but it was prepared by two people who are not here tonight, correct?
Correct.
Okay, and in fact, the last sentence says, if anyone has any questions regarding the findings in the report, they should contact Mr. Magnotta, I believe the first witness who testified in these proceedings, correct?
That's what the report says.
Okay.
Contact him.
And if I understand correctly, the entire premise for your testimony regarding the 25,000 figure, what is that, 25,000 inches?
It's 25,023 caliber inches.
Caliper inches. Thank you. The entire basis for your testimony in that regard is from this report that your name does not appear on and you did not author, correct?
Well, the basis of my entire testimony here tonight is not simply based on the tree assessment survey. This was the basis for developing a plan that meets or complies with replacing at least 25,023 caliper inches of woodlands.
Thank you. The 25,000 figure comes entirely from that report, correct?
Yes, it does.
Okay. And if in fact you referred to the Pannoni report, do you have that handy? I'm looking at page 6 of 18. You mentioned item number 8.
For the record, that report was introduced by the township as T10.
Thank you.
So I'm sorry, repeat again. What?
She's
Sure.
asking you to look at the Pinoni.
Okay.
Do you have the Pinoni report, Andy?
Yes,
And I'm
the
not-
letter,
not-
yes.
Yeah, I just want to look at page 6 of 18, item number 8. Correct? You have that handy?
I'm looking at page 5 of 14, item number 8.
6 of 18. Well, maybe that's it.
So I'm looking at letter, Pinoni letter reissued December 30th, 2025. And number 8 talks about the woodland standards per 184-76.7B for A woodland standards. And I have page 5 of 14.
Okay, thank you. Am I correct that the 25,023 caliper inch figure that's referenced in there comes entirely from the tree assessment
It does.
report that is exhibit A15? Am I correct?
That's right.
Okay. And am I correct in understanding, and I tried to write this down when you said it, the objective of the plantings that are referred to on that screening plan is to quote, screen views of proposed buildings, correct?
Yes, part of that is it serves a dual purpose. It's to replace woodlands and also to meet the property line buffer, which is to screen or mitigate the visual impacts of the development.
Right, you just quote, I had written that down, you just repeated it, thank you. Quote, mitigate the visual impacts of the data center development. That's the objective of the landscape and around particularly around the exterior of the property, correct?
Yes, the property line buffer.
Okay, thank you. I don't have any other questions.
Thank you, Mr. Fogarty. Ms. Sotera, and again, for the record, Ms. Sotera represents a number of individuals, and I'll list them with this witness, so it's in the record. That would be Andrew Pasecki, Michelle Pasecki, Jeff Klump, Dave Lemons, John Gerling, Jessica Schiller, Terry Arthur, Chrissy Jimbrowski, Jason Beechner, and I believe an additional individual was added. Ms. Sotero, was it?
Yes, Ms.
Marlon Lynn?
Marlon Lynn. Yes.
Thank you. Please proceed.
For the stenographer, if you need me to spell her name, I can.
And again, for the record, she was originally pro se and now she is represented by Ms. Sotero.
So Ms. Carr, just a couple of questions. To go over a little bit of what you previously testified to, you used the pointer to show that these plantings, they go all around the property of your client's property, correct?
Correct.
Okay, and this particular design up on the screen, that still contains this proposed relocation of Possum Hollow Road.
Yes.
Okay. And are you aware that there's a proposed alternative plan? It was previously submitted as A7.
I am aware there's an alternative plan.
And have you started making a buffer area and screening plan for that alternative plan?
No.
Okay. So when putting the plan, this design together, I see that the plantings, it goes down to the southern part where there's the Pico substation. Is that correct?
Right.
Okay, you said right?
Correct.
Okay. So when putting that design together, did you understand that this substation as part of this total project?
Yes.
And so you needed to apply these screening and buffer ordinances to the area that goes around the substation.
Correct. There are also other uses or developments associated with this project that will require, I'll say, more intensive screening, and plans for that screening have not been developed yet.
Okay. But you had to apply the ordinances because it's part of the property.
That's correct.
Okay, that's all I have.
Thank you. We're going to move on to our pro se individuals. And again, I remind you, you need to stick to the questions that were asked on direct and for report. So I'll try and redirect you if we start getting too far outside the scope. And again, your questions need to be relevant to what's being testified to. So with that, Ms. Shank, Kim Shank.
Hi, are you associated with the data center development project proposal in East Whiteland at all?
Do you mind speaking a little closer to the microphone? I'm sorry.
I'm sorry. Are you associated with the data center development project proposal in East Whiteland at all?
No.
And again, I don't believe she testified at all about any of this on direct. So I would stick to the report, stick to the conditional use.
Okay. Are you a landscape architect for any other data centers anywhere else?
Not at this time.
You talk about a buffer. Is that a sound buffer to be mitigating sound, or is that what type of buffer are you referring to?
So the code defines the property line buffer as a planting buffer, and my interpretation of the design criteria is that it would replace naturalized woodland vegetation, or could also be an ornamental planting, but it appears the intent of a property line buffer is to mitigate visual impacts. I do know that plants do provide some mitigation of sound, but I am not. That's not my area of specialty, and I can't comment any further than that on it.
This might be a dumb question, but why are we not keeping the existing vegetation and only clearing enough for the buildings? Because these are mature trees that are rooted and can help with sound and what have you.
So the site is being developed, and I'll say the clearing limits or the quantity of woodlands and existing vegetation that's being cleared is in compliance with the code. And there's a balance between developing the site and retaining the existing vegetation. So in areas where there are buildings and parking and roads, it's not just the physical limits of those built improvements that need to be cleared of vegetation. It's the area around them that needs to be created, paths where utilities will be installed. But this would occur on any type of site development, whether it's a data center or a Amazon warehouse or a shopping plaza.
I've seen a lot of malls that keep the existing vegetation, since you're only speaking of the perimeters and you're not speaking of anything else, but okay. So the trees are going to take many, many years, so they can't be considered a buffer to become. You have 85-foot building, and then you have chillers on top of that. I'm sorry, you have an 85-foot buildings, chillers on top of that, and these little tiny trees. So they can't be considered a buffer.
Can you please ask her questions? I know you'll have the opportunity to put your case on eventually and make argument, but ask her questions, please.
Okay. So why are we calling them a buffer?
So that's actually how the code defines the perimeter replanting, or it's specifically defined as a property line buffer in the code, and it's a requirement for this type of development.
And my last Oh, I have two questions, sorry. You said that the responsible party for maintaining these will be, who may I ask again? I'm sorry.
That'll be the applicant or the property owner is responsible for maintaining all the plantings on the site, all the vegetation on the site.
So am I correct in that at one point, the applicant mentioned that they are putting bids out to other people?
I don't, I do not.
And that
That's not correct, and I don't
That's
agree
why-
with your statement.
I could have sworn that we were told that they were putting bids out to other people. And we're waiting to see who was gonna
Is
do
there
that. So who would be
question?
considered the owner?
I'm not sure how that relates to the proposed buffer and screening plan.
But it's maintenance. We have trees now being placed in there and we don't know who's gonna maintain them.
So I'll say, according to the code, before any plan or development of any type can be approved, you have to establish ownership of the property, and the property owner will be required to maintain all the plantings per the code requirements.
Okay. You mentioned a 25 by 100 planting area, 100 by 25 planting area. How far from the transmission lines will you be planting from there?
So actually, this buffer area and screening plan shows, I'll say like perimeter plantings all around the outside of the property, and there are some. You can see anything that's green on the plan is what's proposed for that buffer type module planting. The substation, the switch station, those will all require additional screening to comply with code requirements. But as far as the transmission lines, the property line buffer that occurs under or in proximity to any overhead transmission lines, the plant sizes will have to comply with the clearance requirements of the overhead power lines. So the property line buffer will get planted there, but the plants that are installed may not reach 80 or 70 or 80 feet tall at maturity, because they need to comply with the utility company's clearance requirements for the power lines.
And will they be a single plant or will they be a combination of shrubs and trees like you were saying earlier?
So for everything that's shown on this plan in green will be a combination of plants, a mixed planting types.
And how often will the trees all be trimmed, especially around the electrical area?
So because this is intended to serve a dual purpose, it complies with the property line buffer and also as a woodland restoration planting. These plants will be naturalized. They won't be pruned regularly. They will be maintained to establish healthy plants, but they won't be trimmed, pruned, maintained regularly. The intent is for them to become natural and mature into a woodland type vegetation or woodland type habitat.
Okay. I believe that's all I have. Thank you.
Kristen and Janelle Clocher, do you have any questions that haven't yet been asked? Okay. Lindsay Murtha.
Hello, Lindsay Murtha. Do you need me to spell that? Okay. All right. Good evening. So the site contains wetlands, floodplain areas, ponds or water features, steep slopes and woodlands. Is that correct?
That's correct.
And the plans state wetlands are present, but no wetland areas will be disturbed. Is that correct?
That's correct.
Has the wetland delineation been formally confirmed by the appropriate regulatory agency?
I don't know.
Has every wetland buffer impact been identified?
No, not by the buffer area and screening plan, and no, because a detailed site plan hasn't been developed yet, and I can't say whether or not the wetlands have been delineated, so any impacts I don't know if any impacts have been quantified or qualified.
Okay. Has every stream crossing impact been identified?
I'm going to object. It's beyond this.
Right, this is way beyond the scope of her direct exam. Again, she can testify as to her report. She can testify as to the questions that Mr. Campbell asked her, but she can't testify as to something that's not yet in the record or something she doesn't have knowledge about.
Okay. And that's fine. You can tell me if any of these are not appropriate. The plans identify FEMA's 100-year floodplain areas. Is that correct?
Again, same, it's not for this witness.
Okay. Will there be another witness coming that could speak to those questions?
Well, Mr. Magnato talked in general about the site plan, and we've offered to make him available in the future, but this witness talked about two things. One, the replacement tree plan in order to satisfy the township's ordinances as it relates to the replacement of disturbed trees, number one, and two, the adequacy of the proposed perimeter buffer as it complies with the zoning ordinance and the SOLA. The questions about the floodplain delineation, those things are not part of what this witness testified about.
Okay. And so are you saying they'd be better suited for Mr. Magnato?
Or another witness.
Okay. And will there be another witness who could speak to those, or should I direct those to Mr. Magnato when he's going to be available?
We're going to have other witnesses. I'm happy to talk to you offline and try to coordinate or try to make it more efficient. I don't know where you're going with this. This witness is talking about tree replacement and
I'm just concerned about the environmental impact. So I don't know if there's going to be another witness who can speak more to that.
And just a reminder, anybody that, you'll have your opportunity to put your own case on and call your own witnesses beyond just cross-examination. So if you have an expert in environmental.
Nope, I don't. I'm just curious if that's part of their plan is to provide one, or if this is all we have access to.
Do you have any more questions regarding the tree assessment and what Ms. Carr has?
My questions are probably more so about encroachments in floodplain. So if you're saying those aren't appropriate.
Right, I'm saying that's beyond the scope of what this witness testified to. It's beyond the direct examination. It's beyond her report.
Okay. Thank you.
We are going to take a 5-minute comfort break.
or discomfort.
Or discomfort.
Those things working? Are those things working?
Oh, yeah. They're set up, but not. It's like all these examples. Kill me.
Great.
I'm just gonna behave myself. Sweatshirt on during summertime. That's the way every year. Summertime.
No. The only thing makes the park is it's raining outside. And it's really bad. Yes.
It's raining.
Yes.
Somebody grabbed my seat. So. All those are fun. Yeah.
Those are cool, you said?
Yeah.
I didn't want to go in front of you. That's cool.
That makes me happy to know, man. People doing that. Now I got
Dan, are we, has everyone moved up? Okay. We were just taking an additional minute for the guests that were in the overflow room to fill in the seats for party status. We had some vacancies in the party status. All right, I think we're ready.
All right, I believe we left off on Joanne Konchak.
Good evening. So the township consultant summary says 6,256 4-inch caliber replacement trees are required, correct?
That's right, based on the formula listed in the tree assessment report.
Okay. Are all 6,256 replacement trees shown on the plans here by location and species?
No, so the plan, the planting detail and this plan show a a concept or a schematic level planting where the plant types are defined and shown in the layout and quantity, but not the species.
And are any replacement trees proposed in easements, stormwater areas, utility corridors, or other constrained areas?
This plan shows only, no, this plan shows only the property line buffer planting area. Doesn't show plantings that will be required for stormwater management areas, and it doesn't show additional screen planting that will be required around the substations, any pump stations that are associated. Improvements like that. Doesn't show plantings around the buildings or the parking lots. Those are all required by the code.
So on the total land that you're planting trees, does that subtract the wetlands and the floodplain, steep slopes, ponds, and utility corridors?
No, I'm not sure what your question is, but I'll say the 6,000 plus replacement trees defined in the tree assessment report assume replacing the 25,023 caliper inches of trees with a 4-inch caliper replacement trees. When our buffer area and screening plan calls for a mixture of plants, so it won't be exactly 6,500 plants. It will be more because they are various types and sizes. And we haven't proposed any woodland restoration or property line buffer plantings within any waterways, any wetlands, or any floodplains as they're defined on the site plan right now.
Okay, and you said that a detailed site plan has not been developed yet.
Not where we would further refine and design plantings associated with that.
And then would you be creating that plan, or is that another plan?
A more detailed planting plan for all of the remaining areas of the site will be developed when site plans are prepared and submitted for future potential municipal review.
So natural resource and site capacity is not fully resolved yet as of tonight?
What is shown on the buffer area and screening plan is compliance with the woodland restoration requirements and the property line buffer requirements of the code.
Okay, so just so I understand, then that's not all the 6,256 trees and plantings, trees?
No, it's not. The tree assessment quantifies the number of woodland trees to be replaced as 25,023 caliper inches, or an equivalent in 4-inch caliper trees of the 6,000, I'm sorry, I'll call it 6,500 trees, because our proposed planting plan uses different sized plants and different types of plants, and the caliper equivalent is listed in the table on the lower left-hand corner of this plan, the buffer area and screening plan. It's also listed in an enlarged version in the buffer area and screening plan details. So the total caliper replacement in caliper inches, total proposed planting is 25,510 caliper inches. And the number of total plants to achieve that 25,510 caliper inches is 14,181 plants total of various types and sizes.
So then on the detailed site plan to come, is there potentially going to be other plants all interspersed among the whole site?
There will be other plantings on the site, on the interior of the site in areas not indicated on this plan.
So if I can just interject, I don't want there to be an impression that there, for the purpose of the conditional use hearing, there will be some greater, more robust plan. When and if this is approved through conditional use, the next step would be to come in through land development, and the additional plantings that Ms. Carr has described and discussed would be part of the land development process. There are specific requirements under the conditional use ordinance relating to tree replacement and to the perimeter buffer. And that's why Ms. Carr is talking about those things here tonight. The plantings in stormwater facilities, the additional plantings in parking lots, and at the base of structures, although they might qualify for tree replacement, are not necessarily part of this application because we're not at land development.
Okay, thank you. That's all I have.
Thank you. Leah Sasson. Or did I, that was Ms. Sasson, I apologize. Mr. Bird, you're up. Oh, Leah. Thank you. My list got mixed up. I apologize.
State and spell Leah Sisson, Leah Sisson, Sisson. Ms. Carr, you did not prepare the woodland survey that the 25,038 figure came from, correct?
That's correct.
And the two authors are not present tonight?
No, they are not.
And your name does not appear on the buffer and screening plan, and you've directed questions to Mr. Magnotta, correct?
That's right.
So you cannot speak to how the caliper figures, counts, or species selections were derived, correct?
I can, I'm familiar with them. I reviewed the report, read it, and it was used to guide the development of the buffer area and screening plan and details.
Okay, so on the table, we're looking at about 14,100 caliper inches in trees.
No, actually, that's that table in the lower left-hand corner of the plan we're looking at on the screen, that where it says total count, that's the number of plants.
So if I can interrupt, if it's easier for Ms. Carr to explain her testimony, there's two primary exhibits, A8 and A9. A8 is the overall buffer plan. A9 is the plan that shows those details blown up. So I would just ask Ms. Carr, if either of those exhibits are helpful for what you're testifying about, to ask Mr. Kerr to put the other plan up. Which of the two plans you want?
Would you please put the plan details up?
Okay. Thank you.
So this is the same table that is listed on the plan, and you can see the far right column. It says caliper replacement in inches. There's a tally at the bottom. The total caliper replacement inches is 25,510. The column left of that represents the subtotal counts for each of the plant types, and at the bottom, the 14,181 would be the total number of plants.
Okay, I can't read the table and I don't have it next to me, so I'll just move on, but thank you for putting that up. But it seems like shrubs supply about 45% of the replacement. Does that feel correct?
Yeah, so about, yes, about 45%.
And does the table credit shrubs toward the caliper requirement?
Yes.
And where did that equivalence come from? Is it stated in the ordinance?
It's not stated in the ordinance. The ordinance states that shrubs be included in the replacement plantings, but it doesn't assign a caliper inch equivalent. It doesn't for ornamental trees or I think evergreen trees either, although I would have to look specifically at the wording, but those caliper equivalents are taken from the American Association of Nurserymen guidelines for plant sizes.
Would it be fair to say that without shrubs and just counting trees, there would be short on the requirement?
That would be accurate as a statement, but it would also mean that the proposed planting would not comply with the code. The code requires trees, deciduous trees, evergreen trees, and shrubs be included in the planting.
Okay. And then you testified 10 to 15% mortality, and that applies to the shrubs as well.
It applies to everything, but the question asked was exactly like what mortality rate would you expect from the planting? But there's also a warranty or a replacement requirement within the code.
And then the plan exceeds the requirement by less than 400 inches, which is probably less than like 1.5%. Not going to get you on exact math here, but the mortality that you described is 7 to 10 times the margin. Does that feel correct?
That's correct, but we wouldn't build in the mortality rate into the proposed planting. Because any plants that die are required to be replaced. We would increase the planting area to bolster the buffer area effect, but we wouldn't do it to account for a 10 or 15% mortality rate.
Then you testified that the objective is to screen or mitigate the visual impact of the development. Is that correct?
That's right. One of the requirements is to mitigate visual impacts.
And the buildings are 65 feet at the roof ridge with chillers on top.
I believe the total proposed height, including the parapet, is about 85 feet.
And the schedule specifies canopy trees at a 30-foot minimum mature height and evergreens at 20 feet and does not name the 60 to 80 foot or 25 to 70 foot species you described, correct?
That's right. They're listing tree species be selected for those minimum mature heights.
So the applicant is obligated only to the 30-foot and 20-foot minimums on the plan, not to what you testified.
They're obligated, I guess, if they want to comply exactly with the code, the minimum code requirement. That's accurate, but to comply with the diversity, proposed diversity requirements that we include on the detail sheet, we would include plants that exceed that minimum height, mature height.
And then of the trees, it looks like less than 30% are deciduous, which leaves 5 to 6 months a year.
That's right.
On what did you base your opinion that the buffer is adequate? Did you perform any visual analysis, sightline study, or cross-section from any residents?
So the property line buffer and the woodland restoration plantings comply with the code.
Note 1 says that an assessment of existing vegetation is needed, and that hasn't been done, correct?
So that the code allows for existing vegetation that remains to help meet that woodland restoration area. And that's not been counted in this tabulation for the proposed planting. But if we were to count the existing vegetation, you know, a field assessment of the existing vegetation needs to be done to make sure that it meets the density requirements of the code. In fact, the density requirements of this proposed planting buffer module. So that's a fairly small area on the plan. But again, it's not been counted in, you know, in the tabulation and the proposed perimeter buffer area or the woodland replacement area.
Yeah, this was compared to existing conditions.
I'm not sure like what your question is.
That's okay, I can move on. So there's no buffer and screening plan for the alternative layouts, correct?
Correct.
And you testified that other uses require more intensive screening and those plans have not been developed. So the screening design before this board is incomplete.
I'm going to object. I mean, I made the comment before that the purpose of this witness and the exhibits that have been submitted and a part of this testimony are to establish two things which are required under the ordinance: the tree replacement obligation and the perimeter buffer. There are other, to suggest that the plans are incomplete is misleading, and that's why I object to the question. The other landscaping elements will be part of land development, not part of the conditional use requirements. That's why they're not.
Ms. Sisson, do you have any questions that are related to the conditional use requirement that haven't been asked?
Is there anything on this plan that reaches the height of these buildings ever?
Well, this is a conceptual planting plan, so species are not proposed, but as I know, in response to some earlier questions, we always include a diversity of species. So there are plants that would be included in this planting design that would reach the 80+ height category, but at a mature age
of 30+ years.
15 to 30 years, depending on the tree species, depending on the conditions, site conditions.
Okay. So Ms. Lawson, I would just say the record now reflects that Ms. Carr did not prepare the woodland survey. Its two authors are not present. Her name does not appear on the buffer and screening plan, and the questions were directed on it to Mr. Magnotta. When Mr. Magnotta was questioned previously about the trees and woodland replacement, he testified.
This isn't the time for argument.
It's my closing. It's my closing to this.
You don't get a closing to each witness.
Okay. Then nothing further.
This is cross-examination. It is questions, and they are related to conditional use. They're related to the report that was prepared, and they're related to what she testifies to. You will get an opportunity at some point, many witnesses from now, and after everybody's presented their case, for closing arguments, but tonight is not the night.
Yeah, no party has been able to cross-examine anyone with actual knowledge of these documents, so I have nothing further.
Mr. Byrd. Again, I will say the same thing I've been saying the whole time. Keep it related to conditional use. Keep it crossing what she testified to on direct, please.
Yes, ma'am. I'm going to try my best.
Thank you. Thank you.
My name is Stephen Bird, STEPHEN, BURD. Good evening, board. Good evening, Mrs. Carr. Thank you for coming. So, since we're on this page here with the detail, so for the plantings in the top-down version of it, if you were to fly over with a plane, it's not going to be full tree canopy. You're going to have openings or some of them white circles I think I see, like lower bushes.
That's correct.
So it would appear as like full canopy from the top. You won't have open spaces all the way down to the ground.
No, you would have, there would be open space between plants, in particular at the time of installation before anything has grown or matured.
At proposed full growth and maturity, would it turn into what would appear to be full canopy, or would you have expanses down to the bottom growth?
The intent is to restore or reestablish a woodland habitat, so that there would be full canopy cover.
Okay. On the 100-foot long by 20-foot schematic that you got, that you're going to use as a repeating layout, can we go back to the other print? That's the total site. Thank you. So starting in that northeastern or 10 o'clock, 11 o'clock orientation on the map when we were talking about the skinny line. Yeah, that skinny line, that's the L. So I'm assuming that green is all that 25 foot wide, and then a repeating 100 foot as you work your way around that line. Is that a fair statement?
That's right. So that 25 by 100 foot area is defined in the code as the minimum buffer size, and the code talks about that, 25 feet wide, a minimum of 20 feet wide, continuing around the property line. So property line buffer.
Okay. So as you start to wrap around the border here, you see where the areas start to get noticeably wider. Yes, like right there, it flares out and there's other areas you go around.
Right.
So as that widens out, are you just, if it's 50 foot wide, you stack to a 225 side by side to fill in that whole area? Or is that a whole different layout plan for areas that are not fall within that 25 to 100 foot?
It would essentially be repeating that 25 by 100 feet to cover those areas. But so, just like we would vary the layout of the plants in there so it looks, so it's more natural.
So the two schematics.
Essentially, this would be planted at the same density or intensity with the same number of plants per 2,500 square feet, the same number in the same types in terms of tree, shrub, evergreen.
But the generalized placement might vary a little bit, but the same number, the same plantings.
The same density and the same number of plantings per this module size, 25 by 100 or 2,500 square feet.
Okay. So then as you sweep around and we say we come down to the 7 o'clock, 8 o'clock orientation, to the west of the utility station. So on the bottom side, a little more west.
Over here?
On the other side of the river, heading more west.
Okay.
Yes.
Yeah.
So down around there, I believe you stated something about sloping all throughout that area.
No, I think there are some steep slopes here.
Okay.
I'm sorry if I spoke and said that this is not an area with steep slopes.
I could very well be misquoting. It's not so much as to exactly where it is, but it's to the issue of wherever there is steep slopes. Within it, first off, what is it to qualify in the slopes that you're talking about? Like from elevation from highest to lowest, and from the starting of that highest, how far out are we talking until you get down to the lowest? Is it 25 foot out, 10 foot out? So what's your ratio of that slopes that you're speaking of?
I apologize. I can't say what percentage of slope happens here, what exists currently, and what the developed condition would be.
Okay, so that to me, that area that we'll just say there's a little slope right there. That looks like the 20-foot wide by 100-foot schematic that you're using. On a slope, would you be able to put the same grouping of plantings, say the trees, would they be able to grow on these slopes? Or would you have to have a whole separate type of plant structure for the sloped areas as opposed to standard flat ground?
So again, anything that's shown in green on this plan would be planted at this density. Where the grade is steeper, we might use a different plant species. Where we get close to a wetland area and soils are not as well drained, we would use different species there to ensure that the plants establish successfully and grow. But everywhere, everything shown in green on this plan would be planted at this density. So that quantity of plants and those different types or categories of plants.
Okay, so you can change the plants in there depending on slope structure to fit the density.
That's right.
Parameters.
This is really a concept plan, and it's not detailed and fully
Correct. If I
designed
can
just
help.
to show.
Mr. Burr, please relate it back to conditional use. As you heard, has been established earlier. This is not the final plan. That this will go through land development. If this were to be approved, this is just the very, very first step.
She testified tonight about sloping, so I'm asking a question in regards to the planning of like putting in the sloping, because it looks like they're putting one little set thing. So I'm just trying to clarify to see if that can work on the sloping that you referenced, or if there has to be changes or alterations to it. So I'm asking a question about her testimony tonight in relation to the plannings and that.
Okay, ask your question, and then if you can move on back to conditional use, away from subdivision and land development.
When you went up saying that, or there was a discussion about the interior plannings within the compound, I would assume more ornamental landscaping design plannings. There was stated that they could qualify to plant as your replacement plantings, but in this plan they are not. That's correct.
That's right. Any of the required plantings on the interior of the site may be used to, to comply with the woodland restoration or the property line buffer, but we purposely have not used or counted those plantings.
But moving forward, as you put your final plans together, all of those interior plantings will ultimately take away from the perimeter.
No, that's not the intent. The intent is that we are complying with the perimeter buffer and the woodland restoration, with this proposed planting, and anything beyond that that's required will be in addition to this. So
Now, when you talk about habitat replacement, that's one of your goals, correct?
well, I think I noted that it's important to provide diversity in the woodland restoration, and that in turn supports habitat diversity for other plant and animal, or for other animal and insect.
So the replacing of the diversity of animals and insects with what is there now with an established forest?
Again, Mr. Bird, we're talking insect now. Please stick to the woodland plans. We got to stay cross-examining her on what she testified to and relevant.
With the visual screening aspect. Ideally, within 30 years, it sounds like you'll get your maximum coverage. How much of the building has to be covered or screened out to be considered that you met a standard? I can understand you can put up trees, but they have to visually like how much of the building to say you've met what you have to do.
So the code requirement is not measuring a visual standard. The code requirement is restoring woodlands, 1-for-1 replacement, 1-inch caliper for 1-inch caliper replacement. And that's what this planting plan is intended to demonstrate compliance with that. And in doing so, and locating plants around the perimeter of the property, we also comply with the property line buffer. And the property line buffer is intended to mitigate visual impacts of development.
Is there a standard line to say that it is mitigated, that there's, or is there, it's?
Mr. Bird, I just believe she just testified as to the code requirement.
When it comes down to the survivability of everything and your knowledge of plants and bushes trying to get established and grow to their maximum potential, if it is placed next to an item that generates excessive heat, how much will that stifle the ability?
Again, this is beyond the scope, beyond her report, beyond conditional use.
I'm good then.
Ms. Bassett.
You don't need my name, right? Sorry, I also did give it at the very beginning. All right, so Ms. Carr, which, if any, supporting documents were you given in order to understand the scope of this project?
So I was given or reviewed the tree assessment, all site plan documents prepared to date, all town engineering review comments and information. I also had access to the studies and reports that have been prepared so far. We also do research on the local conditions like soils, weather patterns, land uses. I did visit the property or this area several times.
That answers my next question. If you physically walked on the site, so thank you. Were you included at all on the IPAC or PNDI reports?
No.
Have you worked on sites with historic properties or other aspects?
Yes.
Are you aware of any studies that have been done on these parcels?
No, I am not.
All right, I think I'll wait with the rest of my questions till we have another, there's going to be another landscape design witness, correct? Environmental review.
We'll have other witnesses. This is the primary witness to talk about the tree replacement plan and the adequacy of the perimeter buffer. So if there are questions about them, I would ask you to ask Ms. Carr if you have questions about those two components of the conditional use requirements.
A lot of the questions come down to the nitty gritty. So for instance, the perimeter, the buffer of the trees planted along, say, the perimeter, the property lines. It does say in the code for, I believe, 50 feet spaced. Doesn't mean necessarily evenly, but then that wouldn't be a part of this conceptual plan, would it not?
Yes.
It is included, you mean?
I'm sorry, would you repeat your question?
Okay. So in the code, there's, how many feet it has to be, trees are replanted, especially along the property lines.
Yes.
And so for that being 50 feet between each planting, is that considered, that's added in there onto this, what is it, A8?
E9.
E9? No, this one's A8, right?
Yeah, that's right, that's A8.
So would that be, that's taken into consideration on this conceptual
Yes.
plan?
So that would be the density of the planting or the, frequency of the number of trees planted. So the required density is taken into account, and this proposed planting complies with the high intensity type of buffer planting.
Just looking at like the site and line of sight for people coming in and out of the residential buildings there and then across. That's my question of, that those parts of the code were incorporated in this. But you said there was going to be some differences with a later plan, right? Where it gets into those very particular.
Right. There's subdivision and land development, which conditional use is the limited purpose of this whole hearing is conditional use.
Right.
If an application is approved, it would still have to come back before the board for subdivision and land development. And that's when plans are a lot more detailed and have a lot of the questions that, we've been given some leeway, but a lot of the questions are subdivision and land development and have no relevance whatsoever to conditional use.
All right, I think for now, Ms. Carr, thank you for your answers.
Stephen and Nina Trosha. And again, I apologize if I'm mispronouncing names. I'm trying. I'm not seeing them. Tangerine and Michael Beck. Finally, Josh and Eileen Mangle.
Hello, I'll be brief. In your buffer zone, in accordance with the code and everything, what percentage were you expecting to maintain soil erosion and sediment control for neighboring land areas.
So the purpose,
And again, I'm going to remind you, that is not a conditional use question. That is beyond the scope of this witness. Try and limit it to the woodlands replacement. What
So
she's
her
testing.
testimony about the types of plants which directly affect that isn't applicable?
Finish your question. Most likely no.
Oh, okay. So you testified that this woodlands thing is supposed to be a 1-for-1 replacement, but yet you earlier testified 50 acres would be removed, which is approximately 38 football fields, and you're only replacing it with 19?
so the code requires replacement of the first 50% of the removed woodlands. It's proposed that 38 acres be removed, and we are proposing that 19 acres be restored. So that's in compliance with the code.
I just want the record to reflect you testified that 50 acres is being removed and you're only replacing it with 19.
No, I don't.
We can read it back. I can
I
have
don't
read it back.
agree that I said that, but
Yeah,
it's
you did.
38 acres that are.
Please don't argue with the witness. Ask your question. Let the witness answer.
I asked, and I'm just would like to note an objection on the record that the proposed tenant seems to get a lot of leeway from the board, and I'm actually kind of shocked by that.
Mr. Campbell, any redirect?
Does anybody on the board?
Oh, yes. I apologize.
Ms. Schuler? Dr. Walraven?
Okay.
Mr. Maroon?
Okay. Can you hear me? Okay. First question I have. First question I have is, what is the significance that is rare that a landscape person appears at a hearing? What was the significance of pointing that out?
It's very unusual for the planting design to be brought into question.
Okay, well, what was the significance of bringing that up? I mean, if it wasn't significant, you wouldn't have brought it up.
I think it was, the significance was to highlight that it's rare, it's uncommon for a planting design to be called into question, considering whether or not it complies with the code requirement.
Okay. You referred to the diversity of trees being replaced, and caliber. I have a minimum, at least 20 pages of trees that were responded. Types of trees such as hickory, cherry, elm, maple, hickory, black oak, red maple, white oak, some cherry trees. Would you say that that is a diverse amount of trees?
I did review the tree assessment report and the log of different tree species. I would say that it's diverse, but the assessment didn't include any quantification of any understory plants. So there are a number of tree species listed there because that's the goal of the tree assessment was to quantify and qualify, identify the trees there, basically count them and tabulate them.
But would you say that is a diverse selection of trees?
Depends on what rule of diversity you're applying. So in our
Just saying that
proposed,
there's a large number of different kind of trees.
there are,
My
but
point,
there's a
kind of
scientific
saying.
definition
Okay.
for diversity, and I'll add that in our proposed planting, we always follow the urban forestry rule of diversity. It's a 30-20-10 rule.
We also have some calibers. The minimum I saw here was 6 inches diameter of caliber. Here's one that's 24. Here's one that's 20, 21, 22, 21. This page 27. Now there's other trees on this page, but I'm just trying to give the span of the size of trees we plan on removing here. 28-foot caliber, 20. Here's a 30, a black walnut, 30 feet to 30-inch caliber. 8 years it takes to grow a 30-inch caliber tree. There's another 23, 25, 29. Okay, this is a smaller one, 24. So my point is we got a lot of large trees that on this report are marked as healthy, and you plan to remove them. You also have the latitude and longitude location of these trees. So that tells me that was put for a purpose. My question is, why can you not design a plan to not remove all these trees? Because I see a lot of white spaces here, but that doesn't tell me any of these trees are in it. You had mentioned earlier that the white spaces between the green are existing trees.
That's right. That's existing vegetation.
Okay, so are any of these trees here in that existing vegetation on this list?
No, only the areas where trees are proposed to be removed were included in the tree assessment survey.
Okay. So, and some of this mitigation plan for covering for the visual of the building, a lot of these existing trees can accommodate that mitigation, and here we are removing them. So my question is, why isn't the design using trees that are healthy being built into the plan in the amount of replacement? Okay. Yep, my question is still that. We're supposed to be a talented company. You can't make a design around what's existing. And I'll use an example of a residential development here in Limerick. It was Bratton Road. They left the large caliber trees in place and built around it.
So, Ms. Murray, I believe the witness testified that to the extent possible, tree disturbance is being minimized, but the ordinance
50% is not minimum, sir.
The ordinance permits the disturbance of trees, and the testimony of the witness confirms that the tree replacement plan complies with the ordinance.
Okay, now to be a good neighbor, you're talking about applying to the minimum. What's wrong with like being a good neighbor and going a little higher? You're telling me it's going to take 30 years to see a 60-foot tree grow? I'll be dead. I won't see that tree happen. I'm 61 years old.
We need order. We need the stenographer to be able to record what Mr. Maroney's saying and what the witness is saying.
I appreciate the question, Mr. Murray, but I also believe the witness testified repeatedly that there are additional opportunities to plant that aren't shown on this buffer plan, which is designed to meet the ordinance. When we come in for land development, where to the extent there are additional locations, they'll be shown.
But these trees are already gone.
Trees have to be removed for this development as they would be removed.
I get it, but you're talking about clear cutting all these trees. You're
100%.
not going to need them for at least 2-3 years, but you're just going to right down because it's cheaper and knock down everything.
Well, with all due respect, when we come in for land development and a phasing plan, we can discuss that.
Okay, I'm gonna hold you to that.
Okay.
The other question I have is still, we're mitigating a problem. Mitigating means you're going to prevent something from happening, but you're just putting a minimum. To me, you're not mitigating an issue. You're just doing what's required. That's the bare minimum. People here live here. We expect more than the bare minimum. Now, the other question I have, you said it was 15% more mortality rate on trees,
It's a
10 to 15?
typically accepted that new planting of any type will experience a 10 to 15% mortality rate.
Okay, so why are we not building in?
We're not
with the
building in a plus 10 or 15% because there is a warranty requirement for all plantings. So any plant that dies within the warranty period must be replaced immediately. And then beyond that, this is in the code. Beyond that, there's a maintenance requirement that any dead, diseased plants be removed and replaced for the life of the property use.
Now, will any of these trees be planted during construction or be after?
Ideally, they would be planted as early in the construction as possible.
Okay, so within the probably, I'd say maximum of 3 years of construction, these trees pass on, they're required replacement.
That's right. The code for the warranty period, the code requires 18 months after installation, but the maintenance section is for the life of the use of the property.
Now, would you not say survival rate is also based on conditions?
Yes, that's right. Could be less than 10 to 15%.
Okay, so would you say the conditions we've lately had, and I don't know if you guys, I'm not going to argue whether climate change exists, but in this area, rainfall is less, we're in a drought area. How are these plants going to survive if we're not getting rainfall for ourselves?
So, I'm just gonna say generally for any type of planting installation, the contractor is required to warranty plants for a year. So they water and provide temporary maintenance to ensure that those plants survive, or they have to replace them.
Is there any chance they would design a more hardy plant to plant?
Pardon me?
Meaning a drought resistant tree, something like that
So
that could survive.
That would be part of the planting design. We design plantings and select plants, for the site growing conditions. If soils are dry, if soils are organic, if weather conditions, typical weather conditions here are droughty in the period when they're planted, we would use plants that are more drought tolerant and call for additional maintenance or watering when they're installed.
And the reason I'd asked that, it's tough for young trees to grow. And especially when you're trying to replace large caliber trees and higher trees, they're prone not to survive because it's harder for a large tree to be transplanted into the area. Now I know this because in my wooded area in my house, I have large trees. And some of them are 50 feet tall now since I've been living here. So what I'm trying to point out here is how are we going to mitigate the visual? And then we're going to take about at the 10 o'clock spot, that property there, if they pass, and there was talk of apartments. Now, person on the third or fourth floor is not going to be able to not see that item. So just put that point out. And all right, my biggest concern is how you're going to cover the second and third story if we're mitigating visual. Yeah, I get it to say, oh, it takes 30 years. To me, I don't think we're mitigating the issue there. But that's the end of my question for now.
Okay, are you done? You all set? Okay. I have a few quick questions and then we're gonna take a comfort break. So I'll be very late. When you went out there and when the trees were assessed, did you put in any sort of, I lost my page, but buffer, room for error when you were doing the measurements? These measurements were done in 2025. By the time that we reach a point, it could be 2026, 2027. Is there room for error or buffer in these numbers that you're giving us tonight?
You mean inconsistency in the data that was collected by the tree assessment? So,
yeah, margin of error. There's my question. I wrote down.
The tree assessment, you know, the final tabulation does state that this is, you know, these are approximate figures, and the methodology takes, well, the methodology accurately describes those 19 acres that will be affected and replaced specifically, exactly, because they sampled those areas specifically. They, you know, when they did that methodology was approved or, you know, directed by the town engineer. It doesn't propose any margin of error, any, you know, any additional planting to address any potential margin of error in calculating the number of trees.
Okay. And then were the measurements checked by a second person or subject to any sort of quality assurance or quality check on that?
When a tree survey is done, Supervisor Maroney identified that there were the tree data, the tree locations were taken.
Yes.
So there's always a check to make sure that each
two people
tree was
evaluated each tree.
Yeah. So the report is always reviewed before it's finally tabulated, before it's issued, before it's submitted as you know.
Yeah, maybe I'm not asking that correctly. I'm asking if
someone would
surveyors
review
out
it.
there.
So there were, I believe it was 2 field.
And so that
people.
so did they divide and, I guess my question is, did they divide and conquer, or did one check the tree and then the other check those trees? I'm just trying to understand how a woodland survey functions.
Typically they would go out with a GIS data collection unit, and one person collects the data and the other measures and records.
Oh, so one would go in and be like hickory, cherry, and then somebody else would do the measuring.
Right.
So 2 people on the field, it's not 2 people doing the measuring. It's one, and then the other one's like bogging. Okay.
And you'd usually have only one person doing the measuring, so it's consistent person doing the measuring. So if you know, there's no difference between 2 people taking the same.
Gotcha.
You know,
okay. I just, wanted to know how that actually operates out there. Will the trees be planted relative to the clearing in each phase? Do you know how that cleared and then put up in?
So we're not to that level of detail yet.
I made the comment before that I think phasing of landscaping, including phasing of the berm, of the perimeter buffer, would be appropriately addressed in land development.
Okay. And then who inspects and how often the trees that have been replanted, and what documentation comes to the township, if any?
There aren't any specific inspection requirements in the code, but it's typical for an inspection of the installed planting to be performed upon installation, and then it's accepted as substantially complete. And then at a point just prior to the expiration of the warranty period.
If I can supplement that, I've had the experience of dealing with land development applications that right now it's very common for stormwater management plans, right, to be recorded with specific maintenance obligations. I've seen municipalities that include as part of the land development approval process or a land development agreement, a specific protocol regarding timing of maintenance of trees, a survey of the buffer trees before the expiration of the warranty, and then the warranty or the bond or whatever the security isn't lifted unless that report is issued. I've also seen municipalities impose similar ongoing requirements similar to stormwater. That would be a land development issue.
Okay. And then my final one, and I just, which neighboring properties and public roads did you evaluate the views from for the screening?
So I drove around the property on every road I could get to.
Okay. Did you ever walk into the property?
I did.
Okay. Yeah, I think that's it.
Madam Chair, I just thought of a question while I was sitting.
I do have a comfort break I have to get to for someone, so.
Okay.
Can we
address those two when we come back?
Sure.
We'll be here.
Okay.
All right.
Have you made some sort of announcement as to
Until 11:59 if we have to.
So we have one other witness available, but candidly, I'll speak with my client, my witnesses, and we come back if we can talk about what the appropriate time to break is. I appreciate the willingness to go late. I do, but it is already late, so I'm going to caucus with my client and my witness.
With that being said, then we'll take a comfort break and a quick executive session as well. Okay, thank you.
We're going to discuss ending before midnight. Right. They don't want to go until midnight. Right.
Two hearings in a row is unexpected.
So under the MPC, we have a certain amount of testimony that has to get in. The applicant has to be able to present a certain amount of testimony, and if they're not, that risks a potential deemed approval. So we want to make sure we're keeping it rolling.
7 hours. Wait. They get 7 hours. So he doesn't have to. Probably. More than beer. I like to think so. But they all get no, the lack of communication. I agree. There's so many we're just like and she was showing that online. No, they don't. They didn't. Yeah. They don't. I know. So they never got and they're like, but they should have been kind of defending, should have been saying all of that. Why not? Yeah, right. I had this. Yes, yes. Yeah, let them know. Yeah. It's never gonna accelerate. So if that's. Well, Chester County. We're never gonna get that. I hope not. My uncle lives in litigation. I know, they told me. Security guards have stepped. My uncle wasn't living there, right? But I had an There you go.
Yeah.
All right, we're gonna start back up. Okay, in talking with the board, Mr. Campbell obviously has the opportunity to redirect Ms. Carr. After Ms. Carr, we are going to try and begin with Mr. Campbell's next witness. We're not sure how far we're going to get, but we will not be getting to cross-examination of his next witness. That will certainly be a stopping point, but he may be trying to qualify the next witness as an expert as well. So who knows how far we'll get past voir dire. So at this point, Mr. Campbell, redirect.
Sure. Did Mr. Maroney have his additional?
Yes. Any questions, Mr. Maroney?
Never mind. I'll wait for.
I have a very few questions on redirect. Ms. Carr, you were asked by several questioners about the fact that you relied on a woodlands report that you didn't, a tree assessment report that you didn't specifically prepare, site plans. Is it common and customary as a landscape architect to rely on other plans and reports prepared by other professionals on the team?
Yes.
You were asked questions about the height of the trees that you're planting. If you were to plant from the beginning trees that were 40, 50, 60 feet high, how would that impact the survivability or the viability of those trees?
Well, it would certainly be considerably lower, but it's just not physically feasible to transplant trees that are that large.
In the scale that's required.
And yes, that's right.
And to the extent that you're proposing tree heights, are they consistent with what the township's ordinance's guidelines are?
Yes.
Okay. And in fact, do we propose planting trees that exceed the minimum height standards in the ordinance?
We do.
You asked questions about an alternate plan relating to redesign of Possum Hollow Road. Is there any reason why a similar buffer plan couldn't be designed to accomplish the same requirements if that road was redesigned?
There's no reason why we wouldn't redesign the planting buffer.
You talked about the fact that the tree assessment, for every tree that's measured, the coordinates are recorded, correct?
That's right.
And so in theory, there's a question about sort of how accurate those trees are. The tree survey is anybody, including the township's engineer or someone using those coordinates, could go out and double check the measurements that were made, correct?
That's right.
Are there different standards or ways that a tree assessment can be completed?
Yes.
And in terms on the scale of liberal or conservative, I hate to use those terms, right? But using those terms, would you say that the methods used were more liberal or more conservative? And by more conservative, I mean designed to more strictly identify trees that are going to be replaced.
I would say that the methodology used most accurately describes the characteristics of the trees in each of the 19 acres. And that it's a bit more conservative than other methods.
So though there's not a margin of error built in, you are using the more conservative methods to identify those trees.
Right.
There are I think at least two other uses that are permitted on the site at 75 feet, hotels and office buildings. Are you familiar with that fact?
Yes.
And to the extent that the buffer plan provides a visual mitigation, would it essentially provide the same visual mitigation for those other uses which are permitted at significant heights like 75 feet?
Yes, the heights would be similar, so the effectiveness of the buffer would be similar.
Those are the questions I'll read around that. Thank you.
Mr. Fiorini, recross.
I have no recourse.
Thank you.
Mr. Chesney?
None.
Mr. Fogarty?
Thank you.
And Ms. Sotero? Okay. And again, just Ms. Sotero knows, but for anybody pro se that intends to recross, it is very, very limited, even more limited than cross-examination. You can only cross on the questions that Mr. Campbell just asked, that if you need more clarification.
Ms. Carr, Mr. Campbell just asked you about that. Anybody can go and double check the circumference of those trees, correct?
That's right.
Okay, but this is private property, correct?
Correct.
So that's trespassing if anybody walks on there, correct?
It is, but
okay, thank
it would
you.
be easy enough to ask permission to enter the property and double check tree sizes.
I'm sure it would, but otherwise, not anybody can just walk on the property.
Ms. Otero, if you or your clients want to come on for that specific purpose, please let me know.
My clients will be grateful for that, but just anybody can walk on. Okay, so let me just pause it at there. I actually have a question relating to what Connie asked, if I can just have two questions on that.
Sure.
Okay. So Board Supervisor Lawson asked about the woodland survey and how it was conducted. Were you there personally when it was conducted?
No.
So you did not witness how it was actually conducted?
No, it's
okay. That's all. Thank
described
you.
and
That's all my
documented by the
questions.
tree assessment report.
But you were not there personally to witness this?
No, but
okay. Thank you.
Are there any party status members that have, again, very brief recross on what Mr. Campbell redirected his client on? Ms. Shane?
I don't know this process. I don't want to know this process now that I'm involved in it. But what I do know is that every time we come up here with our questions after we've successfully prepared them, we're told it has to be based on an ordinance. And then tonight we were told in our email that it was landscape.
Okay, do you have any questions for the witness?
These are valid questions. Please listen.
I'm going to ask you to recross-examine the witness. You can make closing arguments.
It's not a closing argument. I'd like to know the process because you keep shutting us down and we're not allowed to talk. Whenever we ask a question,
okay,
we
are there any other pro se party status members that have recross-examination for this witness?
Why are we here? I don't understand why we're here. Because you don't tell us the process. You tell us that it's at a later date. You don't explain. You don't send an email telling us that it could only be property line buffer, wood line restriction planning. If that was told to us, we would have had our questions prepared in that manner. But that's not what happens. Every time we come up here, you tell us we're wrong, and that it's for another group or another time. Well, that's it. Give us an index to tell us. We'll follow it. We're not stupid.
I can't give you legal advice, ma'am.
Mr. Byrne?
I assume I already know the answer to this, but you only said to the one lawyer that her clients could enter. I would also be extended that same courtesy if I reached out to you to have access and be able to get people to try to verify your measurements.
I'm happy to talk to you that offline. We have in the past let other people on the property, and we're happy to do it. I will tell you that there are conditions and requirements that
I'll sign a waiver if I twist it. Cool.
Why don't you reach out to me afterwards?
All right, cool.
All right. Are there any other questions? Seeing none, would you like to call your next witness?
Our next witness is Eric Hetzel. May Ms. Carr be excused?
Yes.
Eric Hetzel, ERIKHETZEL. Yes.
Before we get started, I'm hearing from the board, they're having difficulty hearing. If we have to shut the hearing down and ask people to take a break so that the Board of Supervisors can then resume later and hear the testimony, we will, but they need to be able to hear. Paula here needs to be able to take a record.
Thank you. Mr. Hetzel, what do you do for a living?
I'm a land planner.
And what does that mean?
I went to school for a mix of course offerings that included geography and land planning for my undergraduate degree. My master's degree is a master in regional planning from the University of Pennsylvania, which included coursework in design, policy, law, economics, real estate, really a multidisciplinary collection of things that are integral to the process of land planning.
Where did you get your undergraduate degree?
My undergraduate's from Westchester University.
And what was that in?
Geography and planning.
And then your master's degree was at Penn?
Correct.
And what types of courses did you study at Penn in order to be a planner, or as part of your professional development as a planner?
Well, when I was at Penn, I had already been practicing as a planner in an environmental engineering company, so I had some experience from that aspect, preparing environmental reports, open space plans, things of that nature. Then I went back to school to get my master's degree as I was working full-time, as I mentioned, taking coursework in real estate economics, design, ecology, science, planning policy.
Are you certified by any organization or entity as a planner?
I'm certified by the American Institute of Certified Planners, and I have been since 2001.
Does Pennsylvania license planners?
Pennsylvania does not.
Are there any local nearby states which do license planners?
New Jersey licenses planners, and I have a New Jersey professional planner's license.
Have you prepared fiscal impact analysis reports as a planner in the past?
I have. Over my 25 years plus practicing planning, I've probably prepared several hundred fiscal impact assessments.
Have you been qualified as an expert witness before municipal bodies before as a planner?
I have.
And have you been accepted and qualified as an expert before municipal bodies, specifically as a planner in relation to fiscal impact?
I have.
Have you ever been accepted by a board affiliated or associated with Limerick Township as a planner?
I have.
This year, how many times have you been accepted in Limerick?
Twice. I think I presented 3 times in the past year.
And in each occasion, you were accepted as an expert in the area of planning?
I was, correct.
Have you prepared fiscal impact reports How many fiscal impact reports have you prepared?
I think I testified to several hundred over my 25 years of professional practice.
And have you prepared fiscal impact reports in relation to data center projects?
I have.
About how many?
About 15 in the past 2 years.
What were you asked to do in relation to this project?
I was asked to evaluate the annual fiscal impacts associated with the proposed site plan as they would relate to Limerick Township, Springport Area School District, and Montgomery County.
You were also asked to prepare other plans, correct?
I was, yes.
But for our purposes tonight, I'm going to ask you to focus on your fiscal impact report. You understand that?
Yes.
I'm going to show you a document which I got it right. We're at A16. What is A16?
That is my CV.
A handful of copies. If anybody on the board needs one, they were circulated. I think Mr. Fogarty correctly says on Friday. I have physical copies if anyone. Anything else? So A16 accurately identifies your curriculum VK, your resume?
It does.
All right. I'm offering Mr. Hetzel as an expert in the area of planning and particularly for tonight's testimony as a fiscal impact expert.
Just to be clear, would you be calling him later? I believe he prepared a couple of reports.
Yes, he prepared other reports which he referenced, but for tonight, I just want to review the fiscal impact components. I think it's appropriate to bring him back at a later date after some of the other witnesses have testified, because it just makes sense sequentially for him to comment on other testimony when it's concluded.
Mr. Fury, any questions for Wadier?
Yes, thank you. Mr. Hetzel, your AICP certification is current?
It is.
And are you a licensed real estate agent or broker in Pennsylvania?
I'm not.
Are you a licensed real estate appraiser in Pennsylvania?
I'm not.
So you're not licensed in Pennsylvania to issue appraisals of current or future values of real estate, is that correct?
That's correct.
Without stating the projected value of the project contained in your fiscal impact analysis, because I have an objection to the admissibility of that number, please tell me, was that number derived from an appraisal performed by others?
It was not.
Was the future value of the project determined by any appraisal performed by a licensed appraiser by using any of the approaches to value that's accepted in Pennsylvania?
No.
So just to be clear, it was not determined on a comparable sales approach, a cost approach, or an income capitalization approach?
It was using a combination of some of those methodologies, research that I conducted on the total capital expenditures related to data centers, and estimates that I've seen in literature from commercial real estate brokerage companies that describe the cost to develop core and shell of various industrial buildings. And I used those sources to estimate potential future value, understanding that this purpose of this report was not meant to convey an appraised value. It wasn't represented as that. The purpose was to show an order of magnitude of projected fiscal impacts using a very transparent number that could be adjusted by the consumer of this report under various assumptions of value. Set a baseline assumption that drove my analysis.
And this was all done by you?
Correct.
Do you know which approach to value is most commonly used where there is a projection of future value for a property?
there's usually a combination of values depending on who you ask and for what purpose. The cash flow, a capitalization type analysis is one method that's used. Replacement value, construction value can all be used as proxies for estimating potential future value.
And did you engage in that type of study in order to determine the value?
I did.
I have voir dire on his other qualifications, if I may proceed.
I believe tonight he's only going to be called for the limited purposes of the fiscal impact, and Mr. Campbell intends to recall him.
I think it might be best if I ask my questions for voir dire on his qualifications.
Sure.
Because he did present 3 reports, if I may.
I don't object, but again, what I'm offering Mr. Hetzel as an expert for tonight is in relation to his fiscal impact study, not the other 2 reports they prepared. But Mr. Fury, if you'd like to ask questions about those.
I would, if that's okay, Solicitor Geisler.
Sure.
Thank you. Are you a licensed landscape architect in Pennsylvania?
I'm not.
Do you practice landscape architecture even in an unlicensed capacity?
I don't.
Are you a licensed civil engineer?
I'm not.
So you're not qualified to design stormwater systems or evaluate the effectiveness of stormwater systems?
No, I rely on civil engineers to present their conclusions and base my opinions as a land planner, not as a civil engineer.
And likewise, if you're not a civil engineer, you're not qualified to identify floodplains or the impact of the development on floodplains.
Correct.
And you're not qualified to perform a study to determine the impact of development on the water courses on the property.
Correct.
Or to determine the impact on steep slopes or other sensitive environmental features.
Not to the extent that an engineer would.
What training or experience do you have in developing detailed emergency management evacuation plans for projects?
I have not done detailed emergency evacuation plans, but I've done broader brush land planning related emergency impact assessments for large scale developments.
Are you a certified safety professional?
I'm not.
Have you had occasion to develop or evaluate plans for police and fire protection for projects?
I have.
The fiscal impact studies you performed for data centers, were they large data center facilities such as that is proposed here, or are they micro or single user data center projects?
They were mostly hyperscale in size.
Same question with regard to community impact analyses. Were they for large data or for micro centers?
Large data centers.
And how about with regard to evaluations as to compliance with zoning ordinances and conditional use standards and comprehensive plans? Were they for large scale data centers or for micro centers or single user data centers?
Large scale data centers.
You're not an energy engineer?
I'm not.
You're not a certified energy auditor?
I'm not.
You're not a certified energy procurement professional?
No.
You're not a member of the Association of Energy Engineers?
I'm not.
You're not a certified industrial hygienist?
I'm not.
You're not a traffic engineer?
I'm not.
Do you have experience as a sewage enforcement officer?
I do not.
You're not a lighting engineer?
I'm not.
You're not a sound engineer, so you have no experience in designing, measuring, or evaluating sound impact or sound attenuation measures for a project?
I do not.
Have you prepared any viewshed analyses for this project?
Not for this project.
You did not model potential viewshed impact on the project from surrounding properties?
I did not.
I have a series of objections to Mr. Hetzel's testimony with regard to all 3 of the reports, but specifically with regard to the fiscal impact. I don't know if you want to hear that now or you want to conduct other cross-examination and then hear my objection.
You can put your objections on the record.
Thank you. So I would suggest that as an AICP member and his experience as a land planner, if the board determines that Mr. Hetzel is qualified as an expert land planner, he may only testify, I believe, to section 184-85 of the zoning ordinance with respect to conformance to comprehensive plan and compatibility with existing and proposed adjacent land uses. With regard to the rest of section 85B through G, I would suggest that he's not qualified to testify with regard to those issues for floodplains, wooded areas, steep slopes, public utilities, police or fire protection, visual analysis, and on-site and off-site improvements proposed to mitigate adverse effects. With regard to the fiscal impact analysis, I would object to and ask the board to preclude Mr. Wetzel from testifying with respect to revenue impacts from real estate property tax and real estate transfer tax, as that portion of the report is based on an assumed projected value of market value of the property, and Mr. Hetzel is not qualified to determine fair market value. That would also apply to precluding his testimony under section 184-85E as to impact on the school district. With reference to the conditional use standards under section 184-43, as set out Mr. Hetzel's evaluation of consistency with conditional use standards, if the board determines that Mr. Hetzel is qualified to testify as a land planner, I would suggest that he only may testify with regard to 43A, whether the proposal will significantly negatively impact the use of neighboring properties or the character of existing neighborhoods. But I would object to his testimony and ask for the board to determine that he's not qualified to testify for sections 184-43B through E. Thank you.
Thank you, Mr. Chesney. Do you have one of your questions?
Thank you. After Mr. Ferry's extensive cross-examination there or voir dire, I do not have any additional questions. He asked all the questions that I had noted, so I do not have any additional questions. I do join in his objection.
Okay, I was about to ask. Any objections? Mr. Fogarty.
Just joining the objection, no additional questions, thank you.
All right. Ms. Otero.
Likewise, Mr. Fury did an excellent job. I join in the objection.
Very well, thank you. Are there any pro se status people? Again, you've heard the questions Mr. Fury posed. You've heard the objections raised. If you have something new and different, you can add that, or you can join in as the other attorneys all did.
I do want you to line up and put it on the record, your name and what you plan on doing. I don't know if it's going to be, it will be very hard for her if you all just kind of
So we're going to go
yell
through the
out.
order again.
And
Yeah.
I just want the record to be able to capture all of this.
So we'll start with Ms. Shank.
Kim Shank, join in.
And again, can you please speak into the microphone?
Kim Shank, I join in on the objection.
Lindsay Murtha, I also join in on the objection.
Ms. Konchak?
Joanne Konchak, yes, I agree with the attorney's objection.
Ms. Sesson? Sisson?
Leah Sisson, I join in on the objection.
Mr. Berg?
Stephen Bird, I join in on the objection. I also had like 2 questions. So
Again, you joined in the objections.
Yes.
Are you asking him
Yes.
questions?
yes. So you wound up saying that you were involved with, I forget how many you said, large scale data centers. In what states have you worked on data centers before up until this point?
Pennsylvania,
Strictly just only in Pennsylvania then?
only Pennsylvania.
How many of those data centers have actually gone through completion that you've worked on?
None of them yet have come to conclusion.
So all of them are in the process, or only a portion of the total that you said you worked on are active currently working right now.
That's correct.
Wait a minute. So all of them are active in the works?
Some are more active than others in the application process. I haven't been continuously active with them because it tends to be a long process, and my analysis is one piece of many that gets introduced.
Are any of them kaput? Have any of them been completely denied and then maybe have to reopen? Are they all?
I'm not aware of any that have been denied.
And again, Mr.
All right, thank you.
Yeah, thank you. These are your questions. Fantastic.
Okay, we're just dealing with the fiscal impact, but I have some larger questions about, have you previously worked with MCD7 LLC on other projects?
I'm not.
Have you been involved with the projects in the Whiteland?
I'm not.
When were you asked to conduct this? The 3 reports, but the fiscal impact analysis?
I'm guessing the end of 2025, I believe.
That's all for now. Thanks.
Ms. Sasek, do you join in with the objections as well?
If we object now, is he still going to answer questions about the community impacts or analysis and everything later?
We're going to roll on the objections. I don't know if we'll go on them right now, but for the record is what notes your objection. So later, if there's an appeal, it preserves that issue for you. It's not going to affect what's testified to.
There are still things I want to say about the other report. If we're only dealing with one report tonight, then I'll hold my reservation, hold my objection until other questions.
You can certainly do that. Stephen and Nina Dralshak, Tangerine and Michael Beck. And finally, Josh and Eileen Nangle. Okay, I believe we're going to take an executive session at this point. Yeah.
Mayor, two points. First, Mr. Fury did a great job cross-examining my witness about something that I'm not proposing him for tonight, and my qualification of him for those other things would be and will be different when we get to that. So I would ask the board respectfully to defer any action on his qualifications for things other than fiscal. I have a handful of other questions in response to Mr. Fury's questions for the witness regarding his expertise as a planner who can perform fiscal impact studies.
Okay, go ahead and ask those questions.
Mr. Hutzel, the methods and manners in which you prepared your report, are they generally accepted as means and methods for the purpose of preparing fiscal impact studies among planners?
They are. They're considered industry standard among people in my profession, and they oftentimes appear in township codes as the methodology to follow.
As a planner, is it your experience, is it your understanding what a planner does is to some extent coalesce different disciplines for the purpose of evaluating them and applying them to liens?
That's a correct characterization.
So Mr. Fury asked you lots of questions about real estate value, real estate evaluation, appraisals. Are those disciplines that a planner in preparing a fiscal impact study needs to rely on and look at those sources of information?
They are. I aggregate information produced by those experts to provide an opinion on a broad set of topics.
About how many times have you been accepted as an expert for the purpose of fiscal impact studies in the Commonwealth of Pennsylvania?
I would say as many times as I've prepared them, several hundred times.
Those are the questions that I have.
Thank you, Mr. Campbell. we're going to take a brief executive session.
Because that's just your thing.
Yeah. Yeah. I guess it would have to go out.
Great.
Oh, yeah. Right. That's.
All right, are we all? Pat's back.
Thanks for tuning in.
Okay, we're back on the record. I believe the board believes we may have reached a reasonable stopping point for tonight. As such, Madam Chair, might I suggest a motion to keep the hearing open and continue it until September the 8th of 2026. And it would be at the same location here at the Township Building, 6:30 p.m.
Do I have a motion to postpone the conditional use hearing until September 8th at 6:30?
If I can interject, I appreciate it's an appropriate time to stop. It probably affects what we do on September 8th if Mr. Hetzel is not being qualified as an expert.
We still need to do a little bit of, we're going to discuss that. I'm going to do a little legal research.
Okay.
I don't.
Okay. So I have a question about documents that were provided in tonight's 818 residence packet.
Okay, we can discuss that offline. Again, as I said, the applicant can present evidence during the hearing. What is presented during the hearing, that is the evidence. Anything provided ahead of time is voluntary.
Some of these were township documents that were inside the residence packet that was put online for public use. They were not a part of our digital files. We can talk about that offline. I also want to clarify something at the last hearing where I believe it was Mr. Campbell said, say where they were AI data centers. And I did answer from the audience. I want to put it here on the record with the microphone that the plans, 11, like all these 14 plans, they all had AI data center. Mr. Herzl's.
Okay, Miss Safik, you can make that argument at the end.
Okay, there's other ones. And then the last question is the party status folks. Are we still not allowed to bring in like more than a binder?
I can certainly discuss that with Township Administration. I give the legal advice, not the rules here.
All right, those were the questions or comments I had that I thought relevant for this hearing for future.
I have a motion on the table.
I'll be back on when we convene. Mr. Maris will not be able to.
Okay.
I don't intend to present him on that day, but I've said he would come back. He will come back in the future.
But you will have a witness available, ready to go on September the 8th.
Yes, I will.
Mr. Hetzel will be here.
Yes.
Thank you.
Thank you. Well, I understand the rules on the municipalized planning code with regard to evidence. I know that there was a thought that if a witness is going to be presented or there's going to be exhibits referred to, that there would every effort would be made that it would be provided 10 days in advance, so that we would then have an opportunity to go ahead and prepare.
Yes, the township would prefer that. The
Yes.
board I know would prefer that. I certainly would prefer that. But again, as you know, Mr. Fury, there's nothing,
I know that.
my
I
hands are
understand.
tied.
Solicitor Geisler, I understand. I'm just asking Mr. Campbell to try to apprise
Work
us
harder.
of
Yes.
who our witnesses will be 10 days in advance of the exhibits, so that we can keep this moving forward. Thank you.
Absolutely. Mr. Campbell?
I hope that no one was surprised that Ms. Carr testified, since she was on the list in July and she was here, and I brought her back as the next witness. In anticipation that we might end sooner, I identified Mr. Hetzel. I agree, not 10 days in advance, but 5 days in advance. I will endeavor to continue to give everyone else adequate notice of the witnesses we intend to call.
Thank you. Madam Chair?
I have a motion on the floor. I'll readdress it. I have a motion to postpone the conditional use hearing for MDC 7 LLC until September 8th at 6:30 at the Township Building.
And I so move. So I can't second.
I have a motion and a second. All those in favor? I'll do a roll call. Ms. Schuler? Dr. Walraven?
Aye.
Mr. Maroney?
Aye.
Aye. Thank you, everyone, for being here this evening.